That's why.
बाकी सब मेमो दे दियो
Thank you.
तो मेमो
One thing I'm making a mention, actually, 4 months back, it is 1/3 of her life has already spent in pursuing the remedy. It's a 2012 case Anganwadi. This is out of job. Maybe mention 4 months back. You'll also get
temporary injunction. Please don't mention because it's getting late. If you have any urgent matter, please give the mention memo.
In of the list, Lordship.
I'm sorry.
Lordship, in of the list, Lordship. Withdrawal memo.
Withdrawal memo.
Lordship.
Give the memo.
Item number 9, Lordship.
Item
number 9, Lordship.
Item 9 of which list?
Lordship.
Of which list?
Up to supplementary list, Lordship.
Supplementary is item 9 permitted to withdraw.
Supplementary list, item number 1 for judgment.
I may kindly be taken 1 minute. May permitted to speak 1 minute.
Sir, we are already late, Mr. Murthy. What is the agency?
No, I was actually waiting for it.
Yes, please. Jaldi kaun thu?
The only one BLAPL number, that is 13,418, 418 of
Sir,
23.
what is the urgency? Tell me so that it can be taken up out of turn. What is the urgency?
My humble submission, it was directed by your lordship to list this matter in the week commencing 1st July. But it has not come, my lord. That's
You give the memo, I'll see.
Okay.
Yes.
Item number 1 for judgment.
For the foregoing reasons, therefore, this court is of the considered view that the collector Nayagarh should comply with the order of this direction of this court as contained in the order dated 4/5/2007, passed in WPC number 5588 of 2007 in letter and spirit, by causing a proper inquiry into the matter. Apart from examining the correctness of the procedure adopted by the selection committee, the collector shall also examine the contentions raised by the petitioner with regard to the genuineness of transfer certificate issued by Headmaster Nirvananda Vidyaniketan on 9/2/2008 in favor of the opposite party number 5, if necessary by examining the relevant records of the school. The whole exercise should be concluded within a period of 2 months. It goes without saying that the collector shall grant opportunity of hearing to all necessary parties and pass a reasoned order under intimation to all concerned, including the petitioner.
Item number 2 for judgment.
This court therefore finds no infirmity or illegality whatsoever in the impugned order so as to be persuaded to interfere. From what has been narrated here and before, this court is led to concur with the findings of the appellate authority. In the result, this court finds no merit in the writ application, which is therefore dismissed.
Item number 3 for judgment.
Who is interested? Thus, on a conspectus of the analysis of facts and law and the discussion made thereon, this court finds that both the substantial questions of law framed by this court at the time of admission of the appeal are to be answered against the plaintiff appellants. In other words, this court finds no infirmity, much less any justified reason to interfere with the findings of the courts below, as the plaintiffs failed to prove the relationship between Babaji and Jogendra and consequently their claim of antecedent title over the suit property. Further, this court concurs with the findings of the first appellate court that the suit is barred by limitation. In the result, the appeal fails and is therefore dismissed. There shall be no order as to cost.
Item number 4 for judgment.
There is thus no other option before this court than to remand the matter to the first appellate court to rehear the appeal afresh, specifically on the following point. What would be the effect of the document marked Exhibit 18 with regard to the nature of property under Schedule B and C of the plaint as compared to the other evidence on record? For the foregoing reasons, therefore, the appeals are allowed. The impugned judgment and decree passed by the first appellate court is set aside. The matter is remanded for fresh hearing on the point as framed above. The suit being of the year 1997, the first appellate court shall do well to try and dispose of the first appeals as early as possible, preferably within a period of 4 months from the date of receipt of records.
Item number 5, press admission.
Item 5, my lord, I pray, my lord, pass over.
All right, pass over.
Item number 6.
Yes, item 6. Oh, pass over.
That seniority matter, I'm sorry, my lord, I should have brought to your lordship's notice the previous instruction that was received by us long back in 2012.
Yes.
That may be of relevance for your lordship for consideration.
But since the petitioner is not there, I'm passing it over. Let me pass it over, let him come so that we can. Yes.
Item number 7.
But in this case, my lord, there was an additional affidavit,
You wanted to file a reply affidavit.
but because I had submitted the documents as per the lordship direction, but not in supporting affidavit, my lord. So that is a point which has been raised in this additional affidavit. I had
May I
discussed
please-
with the authorities, my lord, they told us that only 7 days time may be granted, so that
May I plead my
it can
lord?
be taken.
Lawsuits, this matter is already on. You have filed a submitted a document. What happened, your lawsuits, can have a glance to your lawsuits order. By this process, 6 months already has been passed. Your lawsuits are also keep it in powder since long, my lord, no problem.
Mr. Mishra, it's not a question of 6 months. It's a question of trying to find out the correct judgment.
My lord.
So 7 days he's paying. I will grant him 7 days. Next
Within
week,
7 days, my lord.
I will say that there will be no further adjournment.
It's like earlier occasion, my lord also pointed out.
Court lagaya hai.
Yeah,
I'll-
पूर्व କହିଥିଲେ ଆଉ ଥରେ ବି
No,
କହିଛନ୍ତି.
no. For the first time, my lord, on the last occasion, it was directed to me to.
ମାନେ orally the
File-
lawsuits are said,
Mr. Mishra,
my lord. Yeah,
you
orally,
see, we will always look at the cause of justice.
my lord.
If
I'm sorry.
it is, no. If it is required to, I know you are, this is a case of the year 2013, so
No, no.
you have got every right to pay for an early disposal.
My lord.
You have been waiting for more than 11 years.
My lord.
So you have got every right to make that submission. But what I would like to impress upon you is that, you see, the endeavor of the court will always be to find out the
Exactly.
correct judgment.
Right.
कौन बाहर के लिए अपन चेष्टा करे जो स्थिति जो देरी होगी कौन है सर?
Again.
The cause of justice has to be advanced.
Within 7 days, my lord, I will do.
All right. Serious and Patna Granted AGA. 6. A request for short adjournment in order to file the affidavit. In reply to the additional affidavit filed by the petitioner. Shri Mr. Law and Counsel for the petitioner objects to such prayer on the ground that the matter has suffered several adjournments. Stop. In the ends of justice, however, list this matter next week. It is made clear that no further adjournment shall be granted under any circumstances.
May I please, my lord, can it be taken up on 15th?
आज कितने 5
No, next week. Yes. Let it come next week.
My lord, 12th ratio.
12th ratio.
Okay.
Item number 8.
May I please? Last occasion, the state was directed to file a debt check.
There was a, after the lordship direction, my lord, I had submitted the documents. with-
Comprehensive date chart.
Yes, ma'am, with respect to the guidelines relating to the engagement and derecognition of the ASA permission. So, because a good number of documents were submitted, my lord, the lordship wanted to have the copy of the comprehensive date chart from my side. My lord, I have prepared it, my lord. Within the course of the day, my lord, I will submit it. Lordship had already heard this matter. Order may be reserved and I will do within the course of the day, my lord, I will submit.
All right.
And referring to the documents which are already existing, I am not submitting, I am not relying upon any other document.
Learned counsel for the petitioner files a date chart. Learned AGA undertakes to file a
Within
date
the course
chart
of the day.
in course of the day. Heard arguments in full, heard arguments, judgment is out.
Most of it.
आता को रखी लाभो कौन?
Next.
Yeah. If you want to file your note, have you already filed your note?
My lord,
Have you filed your note of argument?
counter agent note has not been paid.
Are you required to file a note? I'll grant you time.
Fine.
The counsel for the parties are, may file their note of submissions and memo of citations, if any, within a week.
Item number 10.
Then, my lord, the last instruction I have submitted by your affidavit dated 1/7/2024. Those records are not available in either of the offices.
So we'll take up the matter.
Yes, Lordship, this is a matter regarding to grant of
Family pension.
family pension and temporary increase, Your Lordship.
So what was the dispute? Why was the record called for?
No, that was since it was not paid and records were not being traced for which it could not be advanced. Yes.
May be permitted, ma'am, because I was undertaking the case. But in the previous case, ma'am, prior to this case, this petitioner approached before your lordships. And the case was disposed of with a liberty granted to the petitioner, ma'am, to make a representation before the authority. Accordingly, in the year 2001, it is claimed by the petitioner that, my lord, she had made a representation before the BDO Kirimira. By that time, my lord, it was the BDO who was taking care of it. But in the meantime, my lord, after the restructuring of the cadres and other things, my lord, the matters are now dealt with by the BEO, Block Education Officers, BEO Kirmira, my lord. So since your lordship put a specific question, what was the action taken by the BDO Kirmira on the representation which was submitted by the petitioner on the basis of the direction of this honorable court? So the BDO Kirmira, my lord, he's made a submission before lordship.
Unable to trace out the,
Unable to trace
so
out.
we'll do one thing.
Then, my lord, I mean, then your lordship, taking into note of the fact that, my lord, that the files have been shifted to, or it has already been transmitted to the office of the BEO Kirmira. Then your lordship directed the BEO Kirmira to file an affidavit. Now, the person who is in charge of the BEO Kirmira, my lord, he is the in additional charge. So he sought for some time, and your lordship granted them 2 months time, and to list his case after the vacation. Now, my lord, I have prepared that, my lord. I have gone to that. On 1/7, my lord, a joint affidavit has been filed by the BDO as well as BEO Kirmira, wherein they sought both the offices, including the office of the DEO, my lord. They could not trace out a file with respect to that consideration of the representation submitted by the petitioner in the year 2001. In the year 2024, my lord, that no such file is readily traceable. So may I pray, my lord?
no, I will, you see, let us put the matter to rest now.
ma'am.
It's a question of family pension.
Yes.
Since earlier there was a judicial order,
Yes.
so we'll do one thing. I'll direct the collector, I'll grant him an opportunity to file another fresh representation, and the collector should dispose it off within 1 month.
He is also relying upon 2 decisions of one of your lordship and another
Yes.
of the case. He can also make
That Divya case.
Suvarna Divya case.
Suvarna Divya.
Yes, ma'am.
And my judgment.
Nilamani Mahanti and others.
Anyway, I will say, I will grant you opportunity to file these judgments and everything and make a fresh. Let us not wait.
Most of them.
The petitioner, learned AG, submits that despite thorough search in the office of the district, the block education officer, the representation said to have been submitted by the petitioner for grant of family pension way back in the year
2001.
in the year 2001 couldn't be traced out. Stop. This court finds that several opportunities have been granted to trace out the file. It appears that the petitioner had earlier approached this court in OGC number 6003 of 2001, wherein direction was issued as follows, paragraph 3, Chapter 1. It is pursuant to such order that the petitioner claims to have submitted a representation, which unfortunately is not available. This is a case of the year 2000. This is the petitioner has been claiming family pension since the year 2001. Under the circumstances narrated above, this court finds no reason to keep the writ petition pending any further. So, it would rather serve the ends of justice better if the petitioner is permitted to submit a fresh representation addressed to
Collector, no, Director of Elementary Education. Opposite, but not
to the competent authority, that is Director Elementary Education. Ajit kalta ho elementary education nahi.
Elementary Education, Secondary Education.
So Director Elementary Education. Bracket opposite party number 2.
Yes.
Ventilating his grievance. He is na her. Her grievance. So his duty is her karo. Her grievance. It shall also it shall be open to the petitioner to rely upon the observations made by this court in the earlier writ application filed by the petitioner, that is OGC number 6003 of 2001, as also any other subsequent decision that may have been rendered by this court relating to grant of family pension. The writ application is therefore disposed of, granting liberty to the petitioner to submit a fresh representation addressed to the Director Elementary Education within 2 weeks
Yes, sir.
from today. Stop. 2 weeks from today, along with all relevant documents and citations. Stop. If such representation is submitted within the stipulated period, the director shall do well to consider and dispose of the same in accordance with law within a further period of 4 weeks.
Yes, my lord.
Stop. It goes without saying that if the petitioner's claim, if the petitioner is found to be eligible to receive, he is found to be entitled to receive family pension, then necessary orders disbursing such dues shall be passed without any further delay.
Oh, please, lord.
Item 11.
ये कितने मैटर होची टोटल?
In this case, your lordship wanted to see the guidelines for appointment of ASHA.
Just one. Yes, Mr. Mishra. Yes, Mr. Das, what were you saying?
Guidelines your lordship wanted to look to.
What was the guidelines prevailing at the time of publication of the advertisement on 15/11/2015?
I am
Yes.
supplying a copy to my learned friend also.
I have already said, already received.
Hmm?
What is it?
Okay.
There is.
In the
For ASHA?
in the counter affidavit, it was stated that the selection for ward number 2, to which the petitioner belongs, having already been filled up, she was not eligible for ward number 1.
I think this is prevalent. 29/8/2013.
Yes, thereafter a revised,
ସେଟା 2016 ରହିଛି।
sir,
2016 କଣ ୟାଙ୍କର 15/11/2015 ସରିଲାଣି ଆଉ ତା ପରଟା କେମିତି ହବ?
13 applicable.
13 will be applicable.
Yes.
What was the dispute, Mr. Mishra?
Dispute, your lordship may see, first in the year 2014 an advertisement was done and the petitioner was selected, but no appointment has been given. In between that qualification has been stated to be 10th pass. And thereafter in 15 there another advertisement has been made. And in the said advertisement the petitioner has filed suitable and no appointment has been given. And the petitioner finding no other way of waited and giving application to them, kindly give me appointment since you have declared that I have been selected for the post of ASHA, but no appointment order has been given. While the matter stood thus, in the year 2017, another advertisement again published stating that Jinkpoda in one number relating them one number 1.
That advertisement you have challenged?
Yes, madam. Because guideline says total for the total village the ASHA will be selected. You cannot fragment it. For every 1,000 population there will be one ASHA. Accordingly,
population ବଢି ଯାଇଥିବ?
ବଢିଲେ ଦିଟା ଆଶା ହବ ସେମ୍ ଗାଁରେ ହବ। ୱାର୍ଡ ତ ସେମାନେ କରିପାରିବେ ନା, ଗାଇଡଲାଇନ ଡଜଣ୍ଟ ସେ ଆବାଉଟ ୱାର୍ଡ ଅର ଏନିଥିଂ ଏଲ୍ସ। ଯେମିତି ଅଙ୍ଗନବାଡିର ଅଛି ତ କାଲକୁଲେସନ କରିକି ଦେବେ ସେମିତି ନାହିଁ ଏଠାରେ।
Okay.
And beyond advertisement they have cancelled it in the year 2017, saying after filing of the writ petition they have filed in the counter affidavit stating that your lordship counter affidavit page 9 of the counter affidavit, probably running page 43.
Running page 23.
43 was the counter टा लास्ट
43 नहीं?
ମୁଁ ପେଜ ମାର୍କ କରିଥିଲି ତ ପାରେ।
Paragraph 10 and 11 of the
43 ରେ ସେ ଦେଲେ ଯେ ପ୍ରଥମ ଥର ପାଇଁ ଯେ 20/3/2017 ରେ ସେଟା ସେମାନେ କ୍ୟାନ୍ସେଲ କଲେ 15 ମସିହାର ସିଲେକ୍ସନ stating that ଯେ 1 ରେ ଯେହେତୁ ସେ belongs to
ward number.
Let us see the guidelines.
These guidelines what my learned senior has supplied to me. In that guideline all have been referred to the 10th 2010 guideline
2010 টা କାଇଁ?
और ଦେଇଛନ୍ତି ସେ ଗୋଟେ ସେଟା ଦେଖନ୍ତୁ କଟି ଯାଇଛି 2800 ଲେଖା ହେଇଛି ହଁ ତଳେ ଡେଟ୍ ପଡିଛି ଉପରେ ଉପରଟା ପଡିଛି
ଫାଷ୍ଟ ଲେଖା inviting reference to the
ନାଇଁ all CDM to all CDM ଦେଖନ୍ତୁ ସେଟା ଗୋଟେ
ଏଇରେ
ନାଇଁ ସେଇଟା ନା 10 ମସିହା ଗୋଟେ ଏଇଠି
ନାଇଁ 10 ମସିହା ତ ଠିକ ଅଛି ଏଇଥିରେ କୋଉଥିରେ 10 କୁ ରେଫର କରାଯାଇଛି ସେଇଟା ଦେଖିଲେ
13 ମସିହା 15 ମସିହାରେ ଯୋଉଟା ଦେଇଛନ୍ତି 24/4/15 ରେ that guideline relating to
24/15 ଟା କାଇଁ
ଦେଇଛନ୍ତି ମତେ ଗୋଟେ ଦେଇଛନ୍ତି
ଆମକୁ କୋର୍ଟ କୁ ଦେଇନାହାନ୍ତି 24/15
ନାଇଁ ସେଇଟା ଆଜ୍ଞା ନୁହେଁ applicable to for me ଏଟା ଏଟା ହଉଛି ଡି ରେକଗ୍ନିସନ ଅଫ ନନ୍ ଫଙ୍କସନାଲ
ଆଚ୍ଛା ହଉ ତାହେଲେ କୋଉ ସେଇ ଯୋଉ 2010 where is that
ସେଇଥିରେ ସାର୍ କହିଛନ୍ତି 2010 ର ଗାଇଡଲାଇନ ଇଜ ପ୍ରିଭେଲିଂ
where is that 2010 guideline
ସେଇଟା ଦେଇଛନ୍ତି 2800 ଗୋଟେ 2800 ଲେଖା ହେଇଥିବ ଦେଖନ୍ତୁ ଗୋଟେ ମତେ ଦେଇଛନ୍ତି ମୁଁ ସେଦିନ ଦେଖେଇଥିଲି ତା ଉପରଟା
2800 ଆଚ୍ଛା ହଉ ସେ this one
24/4/2010
okay 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 this is 2800 2010
ଆଜ୍ଞା ସେଥିରେ
guideline is finalized based on the input and suggestions that meet
ଆଜ୍ଞା।
ଦେଖେ
criteria for selection of ASA
ASA must be a woman and resident of the village
woman she must be in an age group of ete minimum education qualification of the candidate for selection of ASA will be class 8 pass that was subsequently
class 7 ଲେଖା ହେଇଛି
oh, sorry 7 sorry and ability to read and write Oriya with effective community skill and leadership abilities and resident of the village that is important say one Roman 1 ରେ ଲେଖା ହେଇଛି
yes
and they have admitted in the counter affidavit that I have selected but since I belongs to one number 2
there is nothing in this to
No.
show selection
in respect of the wards
ward wise
and the village I have shown on that day a guideline but your lordship stated that where you got from that guideline stated specifically everything has been stated in that guideline
guideline କୋଉଠୁ ମାନେ କୋଉ ଇୟର
ମୁଁ ନେଟ ରେ available ଅଛି guideline ଟା
available in the net then
till it is enforced ସେ ସମାନ କଥା ଏଠି ଅଛି ସେଠି କହିଛନ୍ତି ଯେ କେତେ ପପୁଲେସନ ର ଗାଁ ର ଗୋଟେ ଆଶା ରହିବା ଦରକାର ଏଠି 3 ରେ ସିଲେକ୍ସନ ଅଫ ଆଶାରେ ଅଛି the general norm will be 1 ASA per 1000 population ମାନେ ଦଉନାହାନ୍ତି ସେଇଟା ଅଛି ଆପଣଙ୍କର
how could it be according to him so he is questioning the ward wise selection there is no provision to select ward wise as per population yes you may have multiple asas
Yes.
if one may say that if the population of the village yes yes Learned counsel please if the population of a village is 5,000 so there can be 5 asas for every 1,000 there has to be 1 asa
So whether it can be confined to any ward or
say where there is nothing you find
The
out
counter affidavit is confined to that
no you have to look at the document the guidelines
guidelines.
the health department anyway yes what is your case
in that document criteria is 3 selection criteria is 3 madam selection of ASA जोटा दिल्ली बोर्ड सेठी क्राइटेरिया फॉर सिलेक्शन लो लिखा है जी प्राइमरी ए वुमन रेसिडेंट ऑफ द विलेज in the age group of 25 to 45
so your main
yes madam
contention is that it should not have been ward wise
and 2 times she is selected but not to give your appointment to cancel it after 2 years again
no they can cancel it but the cancellation cannot be arbitrary
no I am not immediately they can cancel at
no. Law is they can cancel
yes
employer I may select you but I may not appoint you I may not appoint you because depending on the circumstances then existing
yes
but the decision has to be reasonable it cannot
Yes.
be arbitrary yes
ma'am
yes sir
My lord, I am the intervener, my lord. Intervener. By virtue of the intervener petition, I am made in party and opposite partner 6, my lord. But I have provisionally selected. Due to the stay order by this honorable court, I could not get an appointment.
yes what is your stand
My lord, kind of glass, I have filed the IA for vacation order, the provisional list, my lord.
so your case is that you are selected
My lord.
no subsequent advantage
subsequently
This advantage, my lord.
anyway
17.
she'll be affected
again
she will be affected if you whatever order is passed she will be affected
again
this court is called upon to find out whether the proper procedure and whether the provisions of the guidelines were followed or not. It has to be legal exercise. You see, hearing is concluded, but it will be difficult to pass judgment, so I will just keep it to next week.
Yes.
There will be no argument.
Counter is confined to that only, that is.
So Vishal, there will be no argument on the next occasion, just simply. Not in part, let's just matter next week. Just remind me. Interim order to continue. I will close it next.
By virtue, by pendency of the writ petition, it become overage now.
Thank you.
Right.
So if you have an interim order, that will not happen.
Interim order ଅଛି ପ୍ରଥମ.
Yes. If at all you win, otherwise, Mr. Sati's client
ସେଟା ତ ନୂଆ ମୋର ସେଠି କରିବାର କିଛି ନାହିଁ କାରଣ I am not a I cannot apply in the new advertisement because they are confined to ward number 1. ସେଟା ରଖନ୍ତୁ ସେଠି
memo କରିକି ଦିଅନ୍ତୁ. File it by FM memo. Memo କରି ଦେଇଦିଅନ୍ତୁ.
The present petition is my lord. Neither the applicant nor belongs to the same ward.
Let us see.
The previous
Question is whether they can make a selection ward wise.
only question is lies there.
Yes. Yeah. Item 12. Oh.
ମୁଁ ଦେଇ ଦଉଛି ସାଙ୍ଗେ ସାଙ୍ଗେ ଦେଇ
The case number mentioned in the counter be corrected in court. They wrongly mentioned each. Please test it. Correction कर दो. Yes, Mr. Panda, what is this matter?
No, this is that time to take instruction.
Oh, Ramakoto 2, only 4 applications were received and application slips were issued to them.
Last
Slip showing the receipt of an application from the
The
petitioner.
lawsuit said that it will be listed on the 11th.
Ah.
But inadvertently, in net it is showing 11th, but in the order it has been mentioned 4th. I sent a letter to restore post
11th को नहीं जिया?
11th. Restore चिट्ठीटा ଦେଇଛି
11th 12th को ना हुआ. Release this matter on 12th July as per for. Item number 13 as per for by the counsel for the petition.
This case, my lord, order under annexure 9, in which, my lord, the services of the petitioner has been disengaged. He working as a Shiksha side. My lord, he remain on leave on maternity ground, my lord. Thereafter, she joined. And after joining, she filed application for leave on medical ground before the concerned headmaster. And it was duly forwarded to the BO by the annexure 2 series. And that after her joining, when she submitted her joining report, annexure 6 was passed. Annexure 6 series, page 26, in which the BO recommended his case to the director for consideration and acceptance with regard to acceptance of her joining report. Thereafter, my lord,
Just.
Annexure 6, page 26.
Just. Annexure 6 is the medical certificate.
My lord. Then annexure 7, page 30. Second paragraph. In this connection, you are hereby informed to attend office of the undersigned along with the concerned CRCC, headmaster, headmistress, and the application dated so and so, the district education officer with necessary supporting documents. My lord, the date was fixed on 10/12/2019 at 10 AM. My lord, I along with the headmaster and CRCC, my lord, I produced the documents and the concerned headmaster was also present on that date. My lord, no action was taken. I filed a representation by the annexure 8 before the district education officer that with regard my acceptance of my joining. My lord, all of a sudden my annexure 9 was passed, in which it has been written in pursuance of the hearing order number 2559/19 dated 17/12/2019 of the DO cum district project coordinator Samagya so and so, who was joined as junior teacher contractual erstwhile Shiksha Sahayika on so and so at so and so is hereby disengaged from the post of junior teacher with immediate effect. But my case is that, my lord, no such order has been passed and no such communication has been communicated to me so far as the 17/12/2019 is concerned. No such decision has been taken, my lord. In the counter affidavit filed by the BO, my lord, they are not whispered a single word with regard to this decision taken by in the hearing, my lord. My case is, my lord, I have not been given an opportunity of hearing when this order was passed. And this order was never communicated to me. And my lord, in the counter affidavit filed by the BO, they has not whispered a single word with regard to that.
You will have to satisfy the court.
Yes.
If whether she was granted
Given an opportunity.
we given an opportunity, that is the only question. If she was given an opportunity, then we'll examine the other aspect. If not, then the matter has to be remitted to the collector for fresh hearing after giving her an opportunity.
Insofar as that opportunity part is concerned, paragraph 7 of the counter affidavit says.
Paragraph 7.
Yes.
After receipt of the report of the block education officer and the document submitted by the
District
petitioner.
education officer cum district project coordinator.
No, 10/12.
On that date, I produced the document.
Called for the personal hearing of the petitioner on 10/12/2019 in order to extend natural justice.
I said, okay, we'll click in the
After hearing.
jump you satisfy the court that your personal hearing was granted.
This was the hearing opportunity given. Thereafter, they have proceeded with the action.
The petitioner it is claimed the petitioner's grievance is that she was not granted any opportunity of hearing by the collector before passing of the impugned order. Stop. Then State Council draws attention of the court to the amendments made in paragraph 7 of the counter. This court finds the same inconclusive. The State Council is therefore directed to satisfy the court, if necessary by filing an affidavit supported by documents, that whether the petitioner was granted opportunity of hearing before passing of the impugned order. Let this matter
26 July. 26 July.
on 26 July. Connected matter also.
Well, this is the first round I have filed for consideration of my annexure 8. When
Disposed of matter.
no, this was not disposed of, connected. Thereafter, I filed this.
See, infructuous issue.
Infructuous, so on type of.
Yes.
I don't know.
See, we connected it. Item kete?
Item 13.
13 hala pura?
14.
13 wala.
Item 14.
I'm filing my rejoinder today.
Sri Das, Learned Counsel for the petitioner files rejoinder affidavit in the court after serving copy on the other side.
Sorry,
Same be kept on record.
I've served copy to office 6.
Yes, I've said that.
15th of 15.
Is this matter on? 19 July.
Public.
Entry monitor.
Entry order to continue.
Item number 15.
Get ready, Mr. Satpathy. Sheeta ଗୋଟେ advocacy ନୁହେଁ କି ଠିକ ପଢିଲା ବେଳକୁ ଦିଆଯିବ Mr. ଅମିତାଭ ଦାସ knows it କଣ କିଏ ମନା କରୁଛି କିଏ ମନା କରୁଛି ସେ ରିଜଲ୍ଟ ଟା ଫାଇଲ ରେ ଥିବ ଠିକ ପଢିଲା ବେଳକୁ ବାହାର କରିଦବ ଆମେ ତ ଶିଖିଲୁ
ଆଜି କାଲି ଫାଇଲ କରିଥାନ୍ତି ମାନେ ଇଏରେ
ଆଜ୍ଞା ଆମେ ତ ଶିଖିଛୁ ସେ ମୁଁ କଣ ମିଷ୍ଟର ଦାସ ଏଟା ଯୋଉ
ଖରା ଯୋଗ ଆସିଲା ତ କହି କହିଲେ ଖରା ହଉଛି ବୋଲି
ବର୍ଷରେ ଆସିଲେ
ନା ବର୍ଷା ନାହିଁ ଖରା ଯୋଗ ଆସିଲାନି ସେଇ ଲୋକଟାକୁ ମୁଁ କିଛି କହିପାରିଲି
ଠିକ item 15 yes item 15
My lord, kindly 1%.
yes
1%.
pass over all right pass over item number 16
May I please? Pensioner is in custody for about 3 years, my lord. The lordship kindly peruse. Lordship, accused your lordship granted bail. Is on the same footing, my lord. After perusing the eyewitness statement, the lordship consider
yes
Your lordship.
what is the name of this petitioner
petition name
Vikram Narendra
Narendra.
Vikram Narendra I think Vikram Narendra Singh the बहुत थिला तंगना है
Yes, ma'am.
where is the deposition
Same, no deposition, your lordship kindly peruse.
दोनों
To son
Same
and daughter.
Same,
the eyewitness.
they abstain.
ये मुझे पढ़ी थी सेम थ्री ଥିଲେ ମୁଁ ଜାଣିବିନି ये प्रीतिमय परिडा
Again. It will be discussed.
informant of this case is my mother deceased Kanu Charan Parida is my father I know the accused their names are Vikram Narendra Singh and Duli Pradhan वाला Vikram Narendra Singh Duli Pradhan Surya Pradhan Haya
Your
Pradhan
lordship granted.
Mr. Mishra look at my land এটা দেখে তুমি except this nothing is that
She has said that.
yes
He said the name of the petitioner. ma'am.
ସେ ତାର ଇଏ ଡୁଲି ପ୍ରଧାନ ନା ବି କହିଥିଲେ
Yes. Duli Pradhan because he is lady your lordship considered. And the weapon of offense that is Kati Bujali was seized from the present petitioner, my lord.
from the petitioner
Yes, my lord.
ତାହେଲେ difficult
2 chapel, 1
regular
Kati.
bail will be difficult
3 years is in custody, my lord.
Mother two case of murder
ପାଖରୁ siege ହେଇଛି.
The last occasion also your lordship heard but not inclined.
Three, all have stated 3 names, my lord. Here your lordship kindly turn to page 10. 10 and others, my lord. Eyewitness
There
stated
around 20 people that is what
people. Yes.
20 people, but this petitioner specifically named.
ସେ ଡାକିକି ଦେଇଛନ୍ତି
Yes.
Only Surya Pradhan and the petitioner.
what about that Pradhan Surya Pradhan
Surya Pradhan,
He has not
no,
moved,
no.
I think.
Others also your lordship granted bail.
others उनका ना କିନ୍ତୁ clearly
Others granted bail because they ତା ପୂର୍ବ ଦିନ ସେମାନେ motorcycle ରେ
regular bail will be
ବୁଲାବୁଲି
difficult
3 ବର୍ଷ ରହିଲାଣି.
regular bail will be
3 ବର୍ଷ ରହିଲାଣି. Your lordship consider for 1 month. he
ମୁଁ
has
ଯାହା
the
କହିଲି
right
ଯଦି ଆପଣ
case
ସେୟା କହିବେ ମୁଁ ତାହେଲେ ସେୟା continuously କହିବି ଆଉ
କହିଥିଲା ଗୋଟେ ଦିନ ଆସିବ ବୋଲି
ଆଉ
ରଖିଥିଲା.
ଦେଲେ ଶୁଣନ୍ତୁ look at this
And that apart, your
among
lordship
others
is the-
Vikram Narendra Singh the petitioner
Yes.
among came to our house and abused my father and searched him saying ସେ କୁଆଡେ ଗଲେ My father ran towards the body side over there, above named person, chased my father holding Katti, Bhujali, etc. I myself, my mother and brother followed them and found my father is lying dead. One thing that is in your favor is that the child witness is unable to say which accused
Yes.
was armed with which weapon. That is the only thing.
That-
Yes, madam.
But your presence cannot be ruled out.
Your lordship kindly
So
see.
Duli Pradhan being a lady and she was for 2.5 years, I took a
In
lenient.
custody 3 years.
Sure.
That apart postmortem report, your lordship. kindly.
That I have referred to in my previous order. I have. So
Not
there are
spinal
four injuries.
of the body, no injury.
No, maybe, but there are four injuries.
4 injury.
Say bleeding
leg re 3টা, eyebrow re gote.
Which is on the right eye. Three of which, 4 lacerated injuries, 3 of which are on the left leg, while 1 is on the right side.
Right side.
Yes.
So the combined effect, it could have led to trauma. So there could be you cannot rule out the nexus between the injuries and the death in such a situation. Regular bail,
3 years custody କହିଥିଲେ ଆସୁ next week ରେ।
ମୁଁ କଣ କହିଥିଲି ମୋର ମନେ ଅଛି
ସେଇଟା ବି ଠିକ କଥା।
ଆପଣଙ୍କର ମନେ ଥିବ
ଆମେ ମନେ ରଖିବା। Consider your lordship will appear in the
regular will be difficult.
for some days your lordship consider.
The petitioner is in custody since
14/8.
14/8/2021 in connection with such and such case. It is submitted that the petitioner has spent more than 3 years in custody by now.
More than near about 3 years.
Nearly 3 years in custody by now. So, and some of the co-accused persons standing on the same footing have been released on bail. Stop. It is further submitted that because of long incarceration of the petitioner, several problems have cropped up in the family which require his personal attention. He may therefore be released at least on interim bail in order to attend to the needs of his family. Learned State Council has opposed the prayer. However, after considering the submissions and taking note of after considering the submissions, this court is inclined to take a lenient plea. Let the petitioner be released on interim bail for a period of 2 months.
6 months.
6.
4 months କର। 3 ବର୍ଷ ରହିଲାଣି 4 months।
ମତେ ଡର ଲାଗିବ ନାହିଁ ଏମିତି ଅର୍ଡର ପାସ୍
ଆପଣଙ୍କୁ ଡର ଲାଗିଲେ ଆମେ ପଳେଇବୁ। 4 months।
all right 4 months each day appearance and all that. Discipline of
Oblige.
Item number 17.
17 not outside us. And this bail application was
1 week after.
not listed. No, my lord. Only I am praying for the trial status report, my lord.
The court below is directed to submit a report regarding status of the trial. Release this matter.
From 19th July.
To court.
26th July.
26 July.
Public.
This order will be communicated to the court below forthwith.
Item number 18.
Please, my lord.
This is specially assigned to me.
That is because of that notification, my lord. Your lordship has disposed of one.
Okay. What is this matter?
Lords, here I have challenged for discharge, my lords. Your
As per
lordship issued notice. In the meanwhile, what has happened is matter has been settled between the parties. I am filing an affidavit, your lordship.
This is what is the offense?
Offense 498 and
0634.
Okay. So this is an additional affidavit to your file.
yes.
So we'll have to ask the parties to appear or what?
Affidavit by the husband, my lords. Lords, the difficulty is this, that the lady is unwilling to appear here. What I am praying is, four litigations were instituted by them. The DB litigation has been withdrawn. I have filed copy. The family court where she claimed maintenance, that has been withdrawn. Now, so far as this litigation is concerned, that is the criminal case is concerned, my lords. There a joint petition was filed between the parties.
For compounding.
Yes. Saying that the parties have compromised. The court is unwilling to entertain that and therefore it was withdrawn. because of the interim orders that this court has granted. What I am praying is, if your lordship will direct the learned SDJ to consider the application filed by both parties there,
Yes.
or the application of the informant, then I think
No, I can say directly say that the court below will consider the petition for compromise or the compounding petition.
will consider the joint petition and pass orders there.
I'll dispose of this application.
Yes.
Granting him
But
that.
my client is having some apprehension that if the interim orders are.
So we'll keep it pending then? We'll keep it pending. We'll say this will not be a bar to
Yes,
consider that.
your lordship may say that.
That will say that.
It will not be a bar to the.
Fair enough, fair enough, fair enough.
One more. In
You are
fact,
there.
yes, sir. In the meantime, this file has been transferred from me, so I have no
You
problem.
file it?
This file has been transferred from me, already been transferred, briefly been transferred. So my name deleted. Still also be passing yours.
You know what Ashwida?
That is the issue.
No, but Mr. Mahapatra, anybody else has been engaged?
No, nobody has.
Nobody has.
Say anyway, I will just refer to
Yes, your lordship may
My
just say.
name not deflected. My name is.
ଆଉ ଆଜ୍ଞା କଣ
ଖରାପ ହବ ସେ ଗଲାଣି 2 ମାସ ହେଲାଣି ମୋର ନେଲାଣି ତ
ସେ କୋର୍ଟ କରେନି ପୁରୀ ଆଜ୍ଞା କୋର୍ଟ ବୁଝିଲେ ତ ହାକିମ ବୁଝିଲେ ତ ଅବୁଝା ହାକିମ ହେଲେ ଆପଣ କଣ କରିବେ
ନା ଆଇ ଏମ୍ ଜଷ୍ଟ ଇଣ୍ଟିମେଟିଂ
ନା ଆପଣ ଯାହା କରିବା କଥା କଲ ହାକିମ ତ ବୁଝୁନି କିଏ କଣ କରିବ Sri Devashish Panda, learned counsel appearing for the petitioners,
Petitioners, yes.
files an additional affidavit in the court, stating therein that during pendency of the case, the petitioner number 1 husband and opposite party number 2 wife
Yes.
have had an amicable settlement of their dispute. Accordingly, a joint petition has been filed in the court of learned SDJ Manugur for compounding of the alleged offences. Sri Panda further submits
For withdrawal of the prosecution and compound.
for withdrawal of prosecution / compounding of the offences. Is it a complaint case?
No, it arises out of a complaint. It was sent for investigation.
156. Sri Panda further submits that 2 other litigations between the parties have in the meantime been withdrawn.
I have given those copies. Orders dated 26/6/2024 at Annexure A.
I'll refer to it. Have been withdrawn in view of such amicable settlement. Copies of the relevant orders have been enclosed to the affidavit.
And the divorce document is also enclosed, Annexure C.
The relevant documents causally enclosed to the affidavit. The Panda further submits that in view of the amicable resolution of the dispute, the parties may be permitted to pursue their joint application in the court below.
In the court of, and the court may entertain.
In such view of the matter, let the learned SDJ Anugur is directed to consider the joint application filed by the parties in GR case number 1028 of 2022 on 26/6/2024 and pass appropriate orders in accordance with law within, let us say,
A fortnight.
within 2 weeks. The order so passed shall be communicated to this court. List this matter. 26 July. 26 July. This order will be communicated to the court below forthwith.
And be
The affidavit will be
uploaded.
kept on record.
And be uploaded. In the meanwhile, no coercive action. That
Interim order is there.
Yes.
Till such time, the interim order shall continue.
Good.
Item 19.
May I clear lots?
I have not delivered first any order.
Non for the opposite party may lots means.
I have not said anything.
They will misunderstood that I will.
Why will they misunderstand you? Whatever order I have passed, nothing is required to be spoken by the opposite party. That is why deliberately I have done it.
Yes. In fact, your lordship has only referred to my submission.
Because, Rabankul? Yes.
A letter was received from Apex.
Oh, apex court. कौन है जी देखिए apex court कौन लिख ले to enable the petitioner. The petitioner was directed to deposit 15 lakhs. If evidence of deposit of rupees 15 lakhs is not furnished by that date, the petition is liable to be dismissed without further reference to the court. This is what the Supreme Court said. हम तो करें लोग हम कौन करूँ? Petitioner से भी appear करना था तो deposit करना था.
Deposit करना.
I'll simply say none appears. None appears for the petitioner on repeated calls. Let's this matter next week.
Lord, on the basis of which this letter has been issued, he has preferred any bail application.
No. He may have preferred. That is why it is it's a bail application, special leave petition criminal. Criminal में bail है तो. कोर्ट उड़े challenge करी सी जाती हो.
He is now not in custody, not a surrender. So 439 application is pending still.
This is the 439 application.
Yes,
He is not in custody.
it cannot be disposed of.
No, cannot be disposed. It is not maintainable if he is not in custody.
Yes.
It will not be maintainable. Modification application was no. You mentioned. I have directed the court below to issue NBW against him because he has not complied with the order.
Mila. Lakshmi says none appears.
Oh, we are directed 50 lakhs. So that probably was modified by the Supreme Court to 15 lakhs. And a date was given. He has not complied with that order also. किसी करो नहीं ये करो खाली just advent कर दो non appears के लिए. He was in custody. In this case, on his submission that he is ready and willing to pay 50 lakhs, I pass that order.
Mila. On the basis of
Yes.
willingness.
The total amount was 9 crore 81 lakhs and to court director petition shall be released on interim bail for a period. Interim bail, that too for 3 months. He neither paid the amount or not surrendered it. And that's why NBW was issued. You find out what has happened, whether that NBW has been executed or not. Sri Nayak Leonard Counsel appearing for the OPID. No, none appears for the petitioner on repeated calls. Sri Anil Nayak Leonard Counsel appearing for the state and OPID matters is requested to obtain to apprise the court as regards the status of NBW directed to be issued against the petitioner. List this matter. 26th July. Item number 20.
Please, my lords, here, your lordship granted me interim bail for the purpose of investigation. I have surrendered and I am filing the surrender certificate. And now the advice is.
Let me just write. Sri Hon'Ble and comes to the petitioner files certified copy of the surrender certificate in court, which shows that the petitioner has surrendered to custody on 3/7/2024. 3/7/2024 after expiry of the period of interim bail. The same be kept on record. Yes.
Lords, now the doctor has advised that I should get ready for hospitalization for surgery on 13th of this month. 13 तारीख तो आगुरु 2-3 दिन आगुरु छाड़ले ये बाकी तो ECG FCG
Take instruction. I will take instruction on this. Ama kodra achi 13 तारीख तो. We will take it up on 9th. 9th or 10th? 10th.
9th हो गया ना 8th तो छुट्टी.
Advice. 8th is a holiday. No, that's all right. But I must grant an opportunity to him.
This is the OPD register of the SC. Or can it come after lunch? He can take instructions.
9th Sri Hon'Ble Leonard Counsel for the petitioner. Sri Hon'Ble Leonard Counsel. Sri Hon'Ble further submits that the petitioner has been advised to undergo surgery on 13th of this month. Learned State Counsel shall take instructions in this regard. Lays this matter on 9th. It happened telephonically instruction. Yes, man. He'll send it by WhatsApp on 9th. So that an order effective order can be passed. I will bring. If he is due to undergo surgery on 13th, then at least he should be available by 12th. On 9th, I will bring positive. Yes.
কত গেছিল 10 তারিখ ভিতরে বাইরে
হ্যাঁ হোক কর 9 তারিখের জন্য সেইদিন অর্ডার হবো
Item 21.
provided that it is genuine.
Yes,
Genuine.
and that's what I
would see same doctor
হ্যাঁ item 21.
But I filed an interim application, IA number 783 of 24.
783.
Yes, ma'am. Seeking extension of the interim bail granted by your lordship. Your lordship granted interim bail on 27/3/24 and he was released on bail on 2nd May 2024.
Well, considering the submissions, the interim bail granted by the order to so is extended by a further period of 1 month.
Well,
1 month.
Item 22.
May I please, your lords. Extension of time, my lord. I filed this IA,
First case, first time.
my lord,
First time it has come.
my lord.
2 weeks.
Item 23.
Obliged, my lord.
Bolarangu Kona. Yes, Mr. Sanapati.
Extension of time, you also kindly say.
You have come, this is, you have come for the first time.
My lord.
I would have time need anything.
No.
All right, 2 weeks.
Item 24.
24, Mr. Sapati was there.
The last order.
So second time around the matter has been listed for correction of the number of IA.
পুଣି ভুলে যাবা
My lord, phone through Buddhist.
আই নম্বরটা দেখি আপনি নিজে করেন
6574.
it will be corrected.
And the matter will be listed on 19th.
List the matter on the date fixed.
Yes.
19.
Item 25.
May I please, your lord. My objection is 20B2C 27A of NDPX settlement. And my custody since 9 to 2021. In this case,
1 week after us.
this person already released on interim bail.
কি লোকাল লোক না বাহার লোক
Local, ये my lord बाहर है.
আমি জানি সারিলেনি কজ টাইটেল এক্সেলেন্ট কজ টাইটেল order can be passed in this case. You are granted bail.
Yes, my lord. By lords.
It is submitted that after being granted bail by this court in the present in BLPL number 2008 of 2022, the petitioner was arrested in connection with another case. As such, he could not appear before the court below on the date of posting of the case, for which NBW was issued against him. He has been taken to custody on, no, he has been remanded. He would have been remanded. He has been again remanded in this case on.
He was, my lord, after releasing on bail, he was arrested in another case. And he was in custody since 8/9/2000.
আগে যদি গোটে NBW হলে তাহলে কোন হলা আর NBW গোটে ইস্যু হলে কি কোর্টে
NBW was issued while he is in custody and it was executed.
তাহলে রিমান্ডের তো নিছি
Yes, my lord.
he was again remanded in this case. হ্যাঁ
Second case টা be brown sugar. So stringent condition.
ব্রাউন সুগার
Yes.
In the second case, it was 18 grams, 15 milligrams
Yes,
of
sir.
brown sugar seized
No,
from four,
no.
four person. And
No, no.
it was not seized.
স্যার আর কিছু সাবমিশন করুন তুমি I will not grant back.
My lord, it was not seized from another.
Maybe. Well, you call for the case diary, we'll see.
The CD was
Case.
called for in the last date.
Do you have the case diary?
খালি adjourn হয়েছে CD. Yes.
Up to date case diary be obtained. তাহলে কাটিয়ে সব লিখুন. Is this matter on 26 July?
Item 27.
Obliged.
উনি জি
Earlier rejected.
earlier rejected from first or second আর কিনতে হবে
Earlier rejected.
Only first. Second application লিখিছি। Second application লিখিছি।
Yeah. How is it maintainable? Because I found a prima facie case of
Yes, my
blackmailing.
lord.
Blackmailing, that is why I was not inclined. So how can a second application by? Learned counsel for the petitioner seeks permission to withdraw this bail application with liberty to renew his prayer before the courts below. Permission is granted with further liberty. First out, second out. Hello.
Item 28, we have a CORAM Mahapatra can take up one.
1 week after,
Interim to
as prayed for, interim order to continue. Never date कर देते 19 July.
Item 29. 29, my lord. Your lordship disposed of the bail application of the co-accused person, who is the principal accused, as first or second hour in A bill appellant 10375 of 2023. My limited role is, my lord, call for the case date and 164 statement of the victim. As I got my limited role is the principal accused twice or thrice, my lord, telephone the victim to the from the mobile phone of the petitioner. This is the only.
He has not been named. This petitioner is not been named in the.
Investigation it came.
Find out. United States Council shall ascertain whether the petitioner has been implicated as an accused in the case or not. If so, the case diary, including statement of the victim, be produced for perusal. Place this matter on
2nd August.
2nd August. No coercive action shall be taken against the petitioner till then.
Item 30.
Let's speak earlier for
Earlier matter, 24th August.
see it, 2nd August.
2nd.
My lord, in this case, I am appealing for the informant, my lord. The,
He wants an adjournment. Wants it to next week.
my lord.
Next week as prayed for.
Item 31.
May I please? 307 and 3SS Act, my lord.
ଯିବ
Yes.
ଓ 3 ଅଛି ତାହେଲେ ପ୍ରମୋଦ ରାୟ କରିଦବ
Judgment is granted bail.
ଏଇଟା ଅଛି ନା ଦୋକାନ ପ୍ରମୋଦ ରାୟ କରିଦବ କନେକ୍ଟେଡ ଜଜମେଣ୍ଟ ଅଛି yes
Password item number 5.
May I please, madam?
yes what is the offense
Offense, my lord, say no offense has been committed, but now here, my lord, the state authority, they have committed the offense, my lord.
yes
The effect, my lord,
Right.
and not by providing me a job of Anganwadi worker.
କେତେ ସେ ନୂଆ ଇଏ ଆକ୍ଟ ଅନୁସାରେ କେତେ ହବ
My lord, may I permit it? Initially, the selection process was cancelled. Thereafter, new advertisement was issued. I was directed to obtain the instruction with respect to the status of the new selection process. My lord, I have already shared the information. I am just providing a copy, my lord. Already a person has been appointed in this. So.
I have a very
They have
limited.
the-
if he has a valid arguable case then that will be subject to result of the
This is the status.
Learned State Council has produced office order dated 18/5/2023, which shows that the selection process as per the advertisement issued on 6/4/2023 has been concluded with one Dahana Pujari
Pujari.
being engaged as Anganwadi worker of the AWC in question. A copy of this order be kept on record. Yes.
May I pray? Because of the fact that appeal provision is there, I have to file an appeal. If my lord permits, I can file.
Okay. So the appeal achi. First appeal, second appeal achi. In course of hearing, the petitioner seeks permission to withdraw the writ application with liberty to prefer appeal before the appellate authority in terms of the revised guidelines dated
15/3/2023.
15/3/2023. Permission is granted with further liberty to the petitioner to prefer appeal
Within 2 weeks.
before the appellate authority, first appellate authority, within 2 weeks from today.
Delay the hell.
ନାଇଁ କର୍ଣ୍ଣଟା ସିଏ କରିବେ ନା ଆମେ ଖାଲି
ଆଜ୍ଞା,
ଦେଖିବା। 2 weeks from today, along with petition for condonation of delay, which will be considered in accordance with law.
Liberally.
Huh?
Liberally. They call you the delay ରହିଥିଲା or my lord may say pendency of this appellate application will contain constitution.
Considered in accordance with law, having due regard to the pendency to the fact that the petitioner, rightly or wrongly, had approached this court
24 to 4.
on 21/4/2023. And the writ application remained pending since then. Yes.
Okay. Item number 6.
In item 6, my lord, I am at fault. I should have brought it to your lordship's notice, but somehow this has missed my notice. This was instruction.
Next week, my lord.
Next week ଆସିବ ତ ଏତେ କଥା କଣ? Business matter next week as paid for by learned counsel for the petition. Friday ତାଙ୍କର ଟିକେ ପ୍ରୋବ୍ଲେମ ସେପଟେ ସିଆଡେ ଯାଇଥିବେ ଆଉ। ନାଇଁ କି ସିଆଡେ ଯାଇଛନ୍ତି? ଟ୍ରିବ୍ୟୁନାଲ ତ ଯାଇଥିବେ ଆଉ କଣ? ଠିକ ଅଛି। No problem.
So item number 15.
Yes, 15. None appears. This is matter next week. Hello. Weekly list. Weekly list order ସରିଯାଇଛି। 41 ଆରମ୍ଭ ହବ। ଠିକ ଅଛି। ଆସିବ।
I mean,
Yes, Mr. Balakrishna.
item 42, hearing list.
ସେ ପଢିବ କି ନ ପଢିବ କାଇଁ ବ୍ୟସ୍ତ ହଉଛ?
I'm not feeling it. That's why I made a mention.
Item 42 ହଁ ମୁଁ ଦେଖେ କୋଉ ମସିହାର କେସ୍?
Weekly,
କୋଉ ମସିହାର କେସ୍?
2003.
2003
Next week.
item 42 next week करते in the week commencing 15th July.
Final.
In the week commencing 15th July. Yes.
Item number 21. Weekly list item number 21.
None appears when the matter is called out repeatedly. Place this matter on. No, you are there, Mr. Pradhan, in this case or in the second case.
Item number 20.
Place this matter in the week commencing 15th July.
19 টা দিলে কিছু weekly 19
সেটা পাসওয়ার্ড ইতনা
19 টা
I'll call it out. You are there. I'll नहीं ଯିବା ଯଦି ଅସୁବିଧା नहीं ଯିବା item 19 yes we there will take it up. Mr. Pradhan wait
19 ରେ
what is the noting appeal notice return on delegation respondent number R2 A with a report refused. We did not back from respondent number 2B.
টু এ উইথ রিপোর্ট রিফিউজড এটা সাফিসিয়েন্ট হবো এডি নট ব্যাকটা
Notice on respondent number 2A is held, no 2B, put it, no 2A is held to be sufficient as notice was received, as it was refused. ये केबे जाइतला notice टा?
সেই দিন গোটে
ये सेटा केबे सेटा
ଯାଇଥିଲା ରିକ୍ୱିଜିଟ୍ ଫାଇଲ୍ ହେଇଥିଲା 12/2/2024 ରେ
तो postal tracking report क्या देलेनी से? The postal tracking report be tagged to the case record, lays this matter next week. Can I be hitch na 6 मास भीतर हेले मिल जिवो 6 मास ऊपर हेले मिल जिवो so we'll take it up next. Yes, देखो 22
Item number 22. Please. It is against.
to the other side, Mr. Manti. Yes, ready.
On the other side, limitation, my learned senior.
admit ହେଇନି
कहाँ
Admit.
की करे petition delay in filing the appeal is condoned subject to payment of cost of rupees 700.
Yes.
কষ্ট নেই
So admit माने delay condoned.
Delay
What is the matter? Let us see whether it will be admitted or not.
against confirming judgment, Lord. The present appellant is defendant number 1. And the respondent number 1 is the plaintiff. And respondent number 2 to 6 are the sons of present appellant. And respondent number 7 is the, he was also the defendant and brother of the present appellant. The suit is for right of easement, mandatory injunction, and permanent injunction. Lords, the appellant, the plaintiff claims right of easement over B schedule property, which has been recorded in my predecessor's name long since. It was also finally settled in favor of my predecessor. That was there. The both the learned courts below On one issue, my lords, they refuse to.
Let us see the issues.
Yes. Only one point, my lords. Let me. submit first.
Yes,
and I will.
yes, please.
On the ground that the village map, on the ground of village map, the right of way has been granted in favor of the plaintiff by the learned trial court, and same is the finding of learned appellate court, saying that within 3 years I have not filed any appeal against that. That is the. Your lordship may kindly see.
What is wrong in it?
Yes. What is the wrong? My lords, the wrong is, my lords, the settlement maps prepared by the Amins are not scientifically, my lords, accurate. That is
You
what.
challenge it. You should have challenged it.
No, there is no evidentiary value. And besides that, my lords, the blindly both the learned courts have relied upon that map. My lords,
If there is no rebuttal evidence, if there is no contrary evidence,
there is no assertion in the pleadings regarding that village map. Straight away, he has relied, he has filed the document, that is Exhibit 5, and that has been considered. Thus, in that view, lords, I have reformulated my questions of law, substantial question of law. That is one. I am also relying a judgment of Review Council. Well, what's my.
yes, Mr. Mahanti, since you have already appeared, I am admitting it. Kote kodna sartho. LCR darkar hai, darkar hai.
LCR ଦରକାର.
LCR sang sang ଆସିଯିବ.
ଆଜ୍ଞା.
Yes. Heard Sri S.K. Pradhan, learned counsel for the appellants. Appellant bodhe.
Singular.
Appellant. Considering the submissions, peruse the impugned judgments, considering the submissions and the grounds raised, comma, the second appeal is admitted on the following substantial question of law.
One and that last one. If Lord, it was a permission. Why I am saying, Lord?
All right.
It's a mango too.
DOF. All right. D and I. Since the respondents have already entered appearance.
Only respondent one.
Plaintiff. Respondent number one.
Contest
Notice.
Notice.
Sri Maheshwar Mahathi has entered appearance for respondent number 1. No notice need be issued to him. To notice to respondent, the other respondents by speed post, fixing a short returnable date. The requisites be filed within 3 working days peremptorily.
Next week, yeah, Lord, say,
within 3 working days ka request chhad diyo, hai na? Call for the LCR. Place this matter on August over date karo.
In the week commencing 12th August.
In the week commencing 12th August. I mean, soft copy nahi hai LCR. Number ke
Item 23.
23.
Lord, delay has been condoned.
Delay has been condoned.
Yes, the respondent has also appeared. It is not admitted. The defendants are appellant against the confirming judgment.
Confirming judgment?
Yes.
Defendants are appellant.
Defendants. Plaintiff sued for declaration of title and permanent injunction. The suit was decreed, holding that plaintiff has acquired title by virtue of a registered sale deed of the year 1980, which I preferred in appeal and lost. So far as plaintiff assertion are concerned, plaintiff has stated in the plaint that on 2/1/1980, the father of the defendants transferred the suit land in favor of the predecessor of the plaintiff.
By virtue of that sale deed?
By virtue of a sale deed of the year 1980. During Hal settlement of the year 1983, they could not record their name, and as such, in Hal ROR, the name of the defendant's father stood recorded. And since in 2003, the defendants interfered their possession suit was filed. The defendants have just taken their stand that there is no transfer by their father and the defendants are in possession of the property. So far as suit is concerned, the defendants have categorically stated in the written statement that though HAL record was passed in 1982, 83, but suit was filed in 2003 holding that it's a bar by time. The trial court,
Who was in possession?
the defendants who are the legal heirs of the original vendor.
What was the finding relating to possession by the courts below?
Courts below have
Let us see the
Yes.
issues.
so far as the ground milord on which I
Issue number 3, you don't run.
Yes. Yes.
Possession over depend করছে limitation টা.
Here I have raised a question that section 42 of the Odisha Survey Settlement Act is bad.
Thank you.
Because on
Correction.
here,
Correction of record of right.
yes. But they have categorically stated in their place.
Their cause of action, whatever, whether they succeed or not is a different matter.
Yes.
But what cause of action have they cited?
But
Their cause of action is disturbance by the-
Yes.
disturbance or cloud over the title.
Yes. But plaintiff has been couched in a manner as if the wrong recording came to their knowledge in 1983, but suit was filed in 2001.
Difficult.
That has been dealt with by the appellate court, but no answer has been.
Sir, difficult case.
on that.
Very difficult case.
Yes. You lordship have a glance
But
over
this court has a little bit of experience.
Yes.
I'll take ধরলাগু ওটা কেমনে লাগিব? এটা ধরলাগু কিছু একটা ফ্ল্যাশ দিতে
In fact, transfer has been effected in 1982. That's right. But you lordship have a glance only for a moment.
No, I am willing to hear you till 5 o'clock.
Yes.
Whatever I felt about it, I told it
Yes.
straight away. This is a pure question of fact. No law involved, no substantial question of law involved, so it will not be admitted.
Still, I have to apply your lordship only one question which has been not answered by the appellate court. Raised and not answered.
What is the
Lordship,
question?
I have glanced paragraph 9 of the appellate court judgment.
Paragraph 9.
Page 6, paragraph 9.
Yes, please.
With regard to the very same point.
42.
Yes. And admittedly, from the evidence on record of the
Sir,
people-
under issue number 3,
Yes.
what the court below has held is completely standing as a bar against you. So the court holds that they are in possession and that there was a threat to their title as well as possession. So they approached the court. It was a honor valid cause of action. So 42 doesn't apply at all.
So far as but so far as the pleadings with regard to this aspect, so far as my recording in my father's name, that has been admitted in their evidence categorically by PW1.
They have to admit.
Yes.
Our settlement, HAL settlement will reach our.
They have knowledge in 1983. Then you are safe. But this aspect has not been dealt with by the.
I will deal with it.
Why not?
Right now, I will deal with it. Don't worry. So I'm not admitting it. You need not appear.
Appeal for this.
Yeah, appear kolo kon hobo? Admission to takar kon role.
As your lordship.
You have no role in the admission. I refuse to admit it.
Only my lordship may allow only for one moment without
Please.
evidence of PW1.
Don't.
In that respect.
Don't. You may, ସେମିତି ନୁହେଁ. ଯଦି କିଛି ବାହାରିବ, I am willing to consider.
And only that 42 your lordship is not inclined to.
Not inclined, ସେମିତି ଭାବନ୍ତୁନି. I can change my mind. If you can convince me, I will change my mind.
No, paragraph 11 of the PW1, which plaintiff number 2, he has said, after 3 years of the sale deed, I came to know about the corresponding MS khata number and plot number of our purchased land and the MS recorded tenant. I have not preferred any appeal against wrong recording of MSRR before any other. Well, so far as their knowledge goes.
This fact is admitted.
Yes.
They did not file any appeal under 42.
And well,
Or rather 42, they did not file any application for correction of record of right. Hold it.
but the appellate
They should have. They did not.
it is if it is not in section 42, then it is under the specific relief.
Need I remind you
No, my lord.
the effect of recording of
No, my lord.
your father's name in the RR?
No, my lord.
It will not convey any title.
Yes.
So
If that is not, that is, the suit is under the specific relief act, limitation, period of limitation is 3 years from the, even if from the date of knowledge.
no. That is the suit is for declaration.
Declaration of title and permanent injunction.
Permanent injunction.
Yes.
On the cause of action, you are disturbing their possession.
You also know so far as injunction, relief of injunction is concerned. But so far as declaration is
No, injunction simpliciter. Don't jumble up.
No,
Injunction simply set up, yes. What you are saying is,
here they have sought for title and permanent injunction.
tell me.
So far as title is concerned, they are pleading in the plain that we have knowledge about wrong recording in 1980. That is in the pleading, in the plain, as well in the plain.
Daki order daki.
Okay.
ନା ମୁଁ ମନା କରୁନି ଆପଣ ଯଦି କହିବାକୁ ଅଛି ଯଦି କିଛି ଗୋଟେ ସେମିତି ମୁଁ ଭାବିଲି ଗୋଟେ କଣ ଭଲ ପଏଣ୍ଟ କହିବି ଆପଣ
ଜଣା ଯାଉଛି ଯେ ଆମ ବାପା ବିକିଛନ୍ତି ଜମି। ଏତେ କଥା ଯେ ଆପଣଙ୍କ ପ୍ଲିଡିଂ।
ସିଏ କ୍ଲିୟର କଥା ଏଥିରେ କହିବା ଆପଣ ଯେତେବେଳେ ଦେଖିଲେ ଯେ ଆପଣଙ୍କର ହାଲ ଆରରେ ଏପର୍ଯ୍ୟନ୍ତ କରେକ୍ସନ ହେଇନି ମ୍ୟୁଟେସନ ହେଇନି
1983 ରୁ 2003 ସୁଟ
and another aspect is also I am willing to grant you that that ସେମାନେ ବି ଦେଖିଲେ ଯେ ଯେତେବେଳେ ମ୍ୟୁଟେସନ କରିନାହାନ୍ତି କି କରେକ୍ସନ କରିନାହାନ୍ତି ସେମାନେ ଗୋଟେ ସୁଟ ଫାଇଲ କରିଦେଲେ ସେଗୁଡ଼ା କଣ ହୁଏନି
ସେଟା ଆମେ ତ
ସେମିତି ଫାଇଲ ହୁଏ anyway this is a suit by the defendants against a confirming judgment passed by learned District Judge Bhadrak in RFA number 77 of 2011 on 5/5/2015 followed by decree. As per the said judgment, whereby the judgment and decree passed on 30/6/2011 and 13/7/2011 respectively by the learned Civil Judge Junior Division Bhadrak in CS number 36 of 2003 -Roman 1 was confirmed. The case of the parties in a nutshell is as follows. The plaintiffs claim that the suit schedule property was sold to them by the father of the defendants by executing a registered sale deed on
7/1/80.
on 7/1/1980. They further claim that possession was also delivered to them and that they have been occupying the property since then. Though the property still stood recorded in the name of the vendor, father of the defendants, even in the Hall settlement, ROR. Stop. The suit was filed in the year 2011. 2003, alleging that the suit was filed. It is alleged that in the year 2003, the defendants created disturbance in their peaceful disturbance by entering upon the suit land. As such, the suit was filed by the plaintiffs.
সেটা স্যার লাস্ট পার্ট অফ 2002 রেজিস্টার আনসার 3 আপন লিখলে
2 করবেন আচ্ছা 2 করবেন as such the suit was filed for declaration of title, confirmation of possession and permanent injunction. The case of the defendants is that their father had not executed. Again, 2/1/1980 লিখুছি 7/1 আপন কইলে সেলডিটা 2/1/80 লেখা আছে জজমেন্ট
Exhibit 1
The defendant's case is that their father had never executed any such sale deed and that the property in question has been wrongly described. It was further claimed that the defendants are in possession for more than 12 years and carrying out brick business over the suit land. Stop. Basing on the rival pleadings, the trial court framed the following issues. Stop. Taking up issue numbers 3, 4, and 5 at the outset, the trial court took note of the oral and documentary evidence on record to be satisfied that the evidence clearly showed that the father of the defendants alienated the suit property in favor of the father of the plaintiffs. And since then,
Father of the plaintiff number 1 and plaintiff number 2.
father of plaintiffs ବୋଲି କରିଦିଅନ୍ତୁ ସେ ସବୁ କଭର ହେଇଯିବ ସେଥିରେ ଆମେ ଡିଟେଲ କୁ କାହିଁକି ଯିବୁ
2 ର father ନୁହଁ।
ନାଇଁ ସବୁ ପ୍ଲେଣ୍ଟିଫ୍ସ କରିଦେଲେ ଚାଲିଯିବ ନା 2 ର କିଏ
ନା 2 ଟା ଅଲଗା ଅଲଗା ଦି ଜଣଙ୍କୁ ସେ ବିକିଛନ୍ତି।
ସେ ତାଙ୍କୁ ବିକିଥିବେ
ନା ନା ଆଉ ବିକ୍ରି ହେଇନି। ସେ ପ୍ଲେଣ୍ଟିଫ ମରିଯାଇଛନ୍ତି ଯେ ତାଙ୍କ ପୁଅ ଆସିଛନ୍ତି ପ୍ଲେଣ୍ଟିଫ ନମ୍ବର 1 2 ହଉଛନ୍ତି ଅରିଜିନାଲ ଯାହାକୁ ବିକିଥିଲେ ଦି ଜଣଙ୍କୁ ବିକିଥିଲେ ଆଉ
ପ୍ଲେଣ୍ଟିଫ ନମ୍ବର 1
ଫାଦର ପ୍ଲସ ପ୍ଲେଣ୍ଟିଫ ନମ୍ବର 2 ଏଇ ଦି ଜଣଙ୍କୁ ବିକ୍ରି ହେଇଥିଲା।
ଆଚ୍ଛା लिखले has alienated suit le
father of the plaintiff
father of
1 and
plaintiff number 1 and plaintiff number 2. And since then they are in peaceful possession of the suit land. The trial court further held that recording of the property in the name of the father of the defendant in the MS ROR is wrong. On such findings, the suit was decreed with and the reliefs claimed for were granted. The defendants carried the matter in appeal to the district court. The district court, after the learned district judge, framed the following points for determination. Para 6 है ना? After considering the evidence and the contentions raised, it was held that the impugned judgment did not merit any interference. Para. Being further aggrieved, the defendants have approached this court in the present appeal, second appeal. Stop. Sir, you are Mr. P.K. Sahu.
SC
Mahapatra. SC Mahanti.
Mahapatra.
SC.
AA.
SC Mahanti. Sri AC Mahapatra, learned counsel appearing for the appellants, would submit that the finding of the trial court is contrary to the evidence on record, in as much as the plaintiff number पे से जो evidence दिखाते
Plaintiff number 2.
plaintiff number 2
PW1.
while deposing as PW1 clearly admitted that the MSROR stood recorded in the name of the defendant's father. Stop. So Mahapatra further argues that according to Sri Mahapatra, this is a vital admission which ought to have been considered by the courts below. Stop. It is further argued, it is further contended that the effect of Section 42 of the Orissa Survey and Settlement Act has not been taken into consideration at all in the proper perspective. Para. I have perused the impugned judgments and have carefully considered the contentions raised on behalf of the appellants. Stop. It goes without saying that mere recording of the property in the ROR is not conclusive proof of title. Stop. In the case at hand, both the courts below have, on the basis of evidence adduced by the parties, have come to a definite conclusion that the plaintiffs acquired title over the suit property on the basis of RSD dated 7/1/1980. Stop. The defendants have not been able to demonstrate as to how this factual handling is wrong or perverse. That apart, the courts below have also found that the plaintiffs were all along in possession of the suit property since the date of purchase. Since the suit was filed, because the defendants claimed entered into the suit property, the bar under section 42, would not apply, as rightly held by the court below. Since it has been proved that the plaintiffs are in possession, they filed the suit when a cloud was cast over their title. In any case, this court finds no justified reason to interfere with the findings of fact rendered by the courts below. As such, there is no substantial question of law involved in the present appeal to consider. In the present appeal for this court to consider. The appeal is therefore dismissed. Yes.
Item 24.
Yes, item 24, none appears. List this matter in the week commencing 15 July.
Item
কোন
25.
মসিয়ার ম্যাটারটা 2018 ঠিক আছে
Praying for an adjournment.
Why?
File misplaced.
File is misplaced. 2023 file is misplaced. Why? All right. As requested by learned counsel for the appellant, place this matter in the week commencing 15th July.
Item 26.
My lord, I am DK so appearing on behalf of Mr. Kesikor.
Yes.
I prayed 2 weeks time.
As requested by learned counsel for the appellant, place this matter in the week commencing
29th July.
29 July.
Item 27.
Here, in the last revision also was placed. There was
You heard earlier.
some sketch map in relation to this. When fact authority point to it.
Sketch map time.
I will place it with relation to two exhibits. Pratham page. Here the dispute arises in respect of a power of attorney. Power of attorney 18 those kindly.
1572. 1572 the part actually.
Power of attorney दिया है क्या?
2800.
Total kindly देखिए map map number 1.
This one.
Yes. Map first page. Set second words. Map number 1.
Yes.
The plot is 1579.
1579.
Total area is 800 decimals. Next map, the power of attorney was given in respect of 1579 400 decimals, excepting 117. The exception is given in the next third map. Whether this description is in conformity with the power of attorney or not, I will place the power of attorney. Then
I think author कहले एठी लिखले ओनर शेयर है 4 decimal 400 decimals.
owner
Power of attorney दिया only 283.
283 excepting 117. The blank portion टा होची 117. The dotted गुड़ाका 283. The sale has been effected out of that dotted share excepting 117. Now the play.
What is wrong with it?
That is exactly what I am saying. That is exactly. Therefore, on the last occasion also, the only grievance is this interpretation of two documents.
So but looking at it on the first blush, you could not have, on the basis of the power of attorney, you could not have touched this undotted portion.
I am a purchaser, different number 3. Power of attorney holder is different.
Anything which is beyond this small square,
yes,
you can say.
Yes, if the boundary is taken into consideration, it is within the share of the power of attorney holder, within the allotted land of the power of attorney holder.
So,
and that has been. Kindly have a glance at the power of attorney. I have also supplied the copy.
That is a very see, plot number 1579 of 200. 1579 by 2048
400 decimals बोली
400 decimal ରୁ ଦକ୍ଷିଣ ଦିଗ ମଧ୍ୟରୁ 117 ଓ 170
ସେ 117 ଟା ଏଥିରେ ଲେଖା ହେଇଛି ଅଙ୍କରେ
170
that is a mistake that has been taken care of by the land trial court. ମୁଁ ସେଠି ବି ନାହିଁ କିନ୍ତୁ ଏରିଆ ଟା ଦିଆ ହେଇଛି 117 ମଧ୍ୟରୁ 117 ଏଥକୁ 14 ମାନେ ସେ 117 ର ବାଉଣ୍ଡରୀ ଟା ଦଉଛନ୍ତି ପୂର୍ବକୁ ପଶ୍ଚିମକୁ ଉତ୍ତରକୁ ଏହି ପ୍ଲଟ ର ସମ୍ବନ୍ଧ ଭୂମି ଦକ୍ଷିଣକୁ ରୋଡ
ଦକ୍ଷିଣକୁ ରୋଡ ଭୂମି ଛାଡି ଅବଶିଷ୍ଟ ଭୂମି ସମ୍ବନ୍ଧରେ ତୁମ୍ଭ ନାମରେ ହଁ
ବାସ୍ ଏକ୍ସେପ୍ଟ 117 ସେ ବିକ୍ରି କରିବେ
117 ହେଲା that blank portion
ସେଠି ଛାଡିଦେଲେ କାହିଁକି ଟିକେ ଦେଖିବେ ସେ ଯୋଉ ସେଲ୍ ଡିଡ୍ ର ମୁଁ ଆଉ ଗୋଟେ ଫ୍ଲାଗ ମାର୍କ କରିଛି that is at running page
yes ତାର ତଫସିଲ କୁ ଯିବା
ଆଜ୍ଞା
ତଫସିଲ ଜମି କାଇଁ
ସେଟା ଅଛି ପେଜ ନମ୍ବର 51 I think
51
exactly within
ଆମ ଗ୍ରାମ ମୌଜାର ଖାତା ନମ୍ବର ଏତେ 442 ବାଇ 285 ପ୍ଲଟ ନମ୍ବର ଏତେରେ 1579 ବାଇ 2048 ବିଲ ଏକ ରକବା 400 ପୂର୍ବ ଦକ୍ଷିଣ କୋଣରୁ 31 ଡେସିମେଲ ବୋଲନ୍ତେ ପୂର୍ବ ପଶ୍ଚିମକୁ ଓସାର 22 ଫୁଟ 6 ଇଞ୍ଚ ଦକ୍ଷିଣ ଉତ୍ତର ଦକ୍ଷିଣକୁ ଲମ୍ବ 60 ଫୁଟ ମାପ ହେବା ଗୃହ ଉପଯୋଗୀ ସ୍ଥଳ
exception plot ରହିଗଲା left corner. I have purchased the land from the eastern corner. But merely without interpreting this document, the learned appellate trial court as
let us see.
Yes. The issue numbers 3 and 4 decide which findings. That finding is starting from paragraph 8. Page the page 9 house. The consideration the page next page 10 about 4 to 5 lines from the bottom, the main dispute.
Yes.
The main dispute between the parties arises to the extent of land allotted to the power of attorney holder, that is defendant number 1. Therefore, it is necessary to first scrutinize the said registered power of attorney bearing number so and so, certified by exhibit 1, and the defendant number 1 find the original power of registered GPA bearing so and so, which has been marked as exhibit B. Same. As stated earlier, the plaintiff has claimed that he had executed GPA in favor of defendant number 1 only in respect of land, excluding 117 from 400 decimals, that is in respect of 283 decimals from plot number so and so. The defendants have denied the said claim and have inter alia pleaded that the plaintiff had executed GPA in favor of defendant number for the entire area of 400 decimals of land from.
But this is a different view. This is a different stand being taken.
Defendant number 1 is a power of attorney holder. I am not concerned with that. Even taking into account the language of the power of attorney, except 117, my purchase is valid. The defendant number 1 has further averred in his written statement that at line 6 of third paragraph of GPA, the total area mentioned for alienation is 400 decimals, but at line 11 of the same para, it has been again written 117 decimals, but 400 decimals from south in figure so and so without any meaning, which might have been a written or subsequent occasion and without the notice of the defendant number one, with some oblique motive for which the court may draw adverse inference so and so. Then the language has been quoted in Odia. The 117 quote କରିଛନ୍ତି. Hence, there is discrepancy in the description of the property in para 3, as the extent of property has been written in figure as 117, but in words it has been written as 170 decimals. And the same appears to be a clerical mistake. But it is clear that there is no mention of executional power of attorney in respect to the entire area from plot number so and so. Therefore, the defense taken by defendant that the plaintiff has transferred the entire area of so and so from plot number 8 to defendant number 1 to the registered power is not tenable. It is forthcoming that the plaintiff has executed the power of attorney in respect of the land except the southern portion, kindly have a glance.
Yes.
It is not the entire southern portion, except the southern portion of plot number so and so. Moreover, the defendant number 1 who has been examined at DW1 had stated during cross-examination at para 21 that Anil Kumar Sahu has not given any authorization letter. Anyway, the defendant number 1 has relied on the money receipt so and so. The money receipt, that is exhibit A, but on perusal of the same it is found that the extent of land mentioned therein has been overwritten without any initial so and so. The GPA number 53/2 is a registered document, whereas the money receipt is an unregistered document, and the defendant number 1 has not examined any independent witness to prove the same. Moreover, overwriting has been made in exhibit A, which creates doubt regarding so and so. In view of the above discussion, it is held that the plaintiff has successfully discharged the burden to prove that he has executed GPA number so and so in respect of 283 decimals from plot number 8, excluding now 117. Now, 117, that has been discussed in page, running page is there, 49.
49 ତ ନଥିବ।
ଗୋଟେ corner ରେ ତଳେ ସେଟା ପେଜ ଛୋଟିଆ ପେଜ ରେ ଲେଖା ହେଇଛି 15 15 ଏଇଠି ସେଟା ଗୋଟେ ଲେଟର ଟା ସେଥିରେ from the top about 10 to 11 lines from the top, therefore the sentence, therefore it has not been proved. It has not been proved by the defendant that the plaintiff was present during so and so. Now coming to the registered cell deed number so and so, it is seen that the vendor in the cell deed is Anil Kumar Sahu through his general power of attorney, holder Suresh Kumar Padi, defendant number 1, as per registered general power of attorney number so and so, and purchaser is Ravindra Kumar Mahapatra, defendant number 3.
So you say that this is a perverse finding.
Perverse. He has not taken into consideration the exact language of the GPA vis-a-vis the registered.
Let us see how the first appellate court deals with it.
Appellate court that has confirmed. To 14. Same, the accidental.
Very a substantial question.
Yes.
You want to review data? You just paraphrase it by saying that whether the courts below, whether the findings of the courts below is perverse, say factual issue.
No, factual. It is completely non-consideration.
ସେଟା perverse ବୋଲି କୁହାଯିବ ସେମାନେ ଅଲଗା ପ୍ରକାର ତାକୁ ଇଏ କରିଛନ୍ତି।
Interpretation of document is completely wrong. That is also a substantial question of law. If the interpretation of two documents are not correct at all, then that's also a substantial question of law.
Only on that ground will.
Yes.
Let's see DP Mathi, then counsel for the appellant.
Ground number C ta page 9 रे exactly. Detailed ହେଇଯାଇଛି।
ଏରେ କଣ କଭର ହେଇଯିବନି ନା ନାଇଁ?
ଏଟା ହଉଛି description of the property.
I'll shorten it.
हाँ.
Produce the informed judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial question of law. One, whether the courts below, whether the interpretation of the general power of attorney marked exhibit B and the sale deed marked exhibit D. এটা সেটা হলো B, এটা হলো D, হ্যাঁ, by both the courts below as regards the description of the property in question is correct. এতে কি হলো সব কভার হয়েছে। Issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. LCR দরকার ନାହିଁ, let us call. ଆପଣ certificate copy ଦଉଛନ୍ତି ନା?
Online copy ପଠଉଛନ୍ତି।
Call for the LCR.
Certificate copy ଅଛି ମୋ ପାଖରେ।
Let this matter.
20th August.
The week commencing 27th August.
28.
28 minutes is against a reversing judgment. The defendant is there. Defendants. But the question here, the plaintiff, your lordship may kindly turn to page 5 of the appeal memo.
Yes.
These are the property belongs to Sashikanta Mishra. Right, sir? Now, question is whether there is one Durga in the middle. Dead. Tankari, these two daughters of Durga are the plaintiffs claiming half share. Claiming their 1/8 share.
Yes.
Now the question was that they being daughters are not entitled to any share. That was taken for whatever it is. In view of the Supreme Court judgment, that contention is wrong. The the first appellate court, the trial court said there is no coparcenary existing. So therefore, there being coparcener doesn't arise. This is the learned lower appellate court comes to the correct conclusion of law, but has failed to understand. Your lordship may kindly see that part of the judgment. Page 24, that is paragraph 19.
Sir.
Of the lower appellate. So in view, lordship got it?
Yes.
So in view of the said decision, that decision of that, section 6 of Hindu Succession Act confers status of copartner on the daughter born before or after the amendment in the same manner as son with the same rights and liabilities. As the right in copartner is by birth, it is not necessary that the father of the copartner should be living on that appointed date. This is important. The copartnery must exist on 9/9/2005 to enable a daughter of a copartner to enjoy the rights. This is the key. If the copartnery exists, daughter is entitled to a share. This is the correct position of it. But now, kindly see, learned trial court has come to a specific finding that there is no copartnery existing. But I'm just giving a two pages. Lordship, see, if there is one word breathing that exists a copartnery, then I have nothing. Plain and simple that the property belongs to them.
The recorded tenant, Sashikanta Mishra, died in the year 1984, leaving behind his wife who died in the year 2001.
Not a single word that the copartnery existed and this is copartnery property, I am entitled to it.
And they were alone, these surviving heirs of Sashikanta Mishra. Of Durga, I'm sorry.
But a daughter's daughter.
No, daughter's daughter. Hey, daughter's daughter hele to hobo nahi.
That's what I'm saying. Hobo as per the newer decision. But there must
limited to the extent of the daughter, their mother, through whom they are claiming.
So therefore, the copartnery must exist. It must be a copartnery property for them to become a copartner.
Obviously, that is.
So therefore, there is no, and trial court exactly held.
Why did the trial court hold that there was no copartnery? Can we see that finding?
Yes, that.
On what basis?
See page 39 of the
39. Yes, sir.
About 5-7 lines, though admittedly. Top row.
Top row.
Top row,
No, page, internal page 9 to?
9, no, internal page 9.
1, 2, 3, 4, 5, 6, 7.
Go admittedly.
Do admittedly.
The recorded tenant Kushtachandra Mishra, who was the maternal grandfather of the plaintiffs, have died in the year 1984, which is much prior to the commencement of Hindu Succession Act 2005. And in view of the aforesaid decision of the Honorable Apex Court, the daughter of a Hindu male becomes a co-partner in the joint family properties by birth. They can have a birthright for which the year of death of the father of the female heir is immaterial. And in view of the said decision, daughter of a co-partner shall become a co-partner in her own right in the same manner as the son. This is the correct position of law. However, in view of the decision reported in so and so, matter so and so, has held only living daughter or living co-partner should be entitled to claim a share in the ancestral property, and the decision of the Honorable Apex Court decided in the matter of Prakash and others so and so would still hold good and precedent on the issue of the co-partner for the purpose of right of it. On the issue of a death of a co-partner for the purpose of right of a daughter to the ancestral properties, and in the manner the decision given in the Damana case as discussed supra has been overruled. Honorable Apex Court in the decision Tulsi has discussed supra. In the case at hand, admitted the recorded tenant Kushtachandra has died since 1984, and his fourth daughter, who was the mother of the plaintiff, has also died in the year 1991. And in view of the aforesaid decisions reported in so and so, being supported by decision reported matter Prakash and so and so, so and so, the living co-partners can have the right to claim partition of and separate possession in respect of co-partner property. But in the present case, the plaintiffs are not the living daughters of living co-partners or the living co-partners for which they are not entitled to seek partition of the joint family properties, which is alleged to be co-partner properties of parties, even though there is no such pleading to the effect that the suit properties are the ancestral and joint family properties.
ମା ବଞ୍ଚିଥିଲେ ହେଇଥାନ୍ତା କିନ୍ତୁ ଏଠି ସକ୍ସେସନ ଓପନ କଲା କୃଷ୍ଣଚନ୍ଦ୍ର ମିଶ୍ର ମଲା ପରେ 84 ରେ
By that time the daughter was
no but the daughter was alive
94 so much
91 na kebe
sorry 91 I'm sorry 91
so she had succeeded whatever interest she had acquired, she had inherited to that interest.
Co-partner inheritance
I'm sorry
therefore question is claim kari parthate if they could have proved that there is a co-partner property possibly tinita generation hobo so if they would have proved or pleaded even that this is a co-partner property, we are members of the co-partner, we want to share. That is
যেহেতু তাଙ୍କ মা মরি ଯାଇଥିଲେ so let us see what is the substantial question you are putting.
The question is sufficient, I think. Your Lordship may see my questions.
Where is it, sir?
Page 9.
এটা করতে হবে
এটা sufficient.
এটা sufficient.
That is the only that is the
Sri Ramakanta Mahathi, learned senior counsel with
Manas Ranjan Das.
With Sri Manas Ranjan Das, learned counsel for the appellants. Considering the submissions, there is the impugned judgments. After considering the submissions and the grounds raised, the substantial question of the second appeal is admitted on the following substantial question of law. Page 9 of the appeal member, जो A लिखा है जी, सेटा कर दो capital है. से गोटा का रहेगा coverage.
Set coverage.
Issue notice to the respondents by registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days. List this call for the LCR. LCR actually दरकार नहीं, but interpretation of law. How correct? Soft copy. Call for the LCR. List this matter. August 27th August. What interim application?
The application of final degree. So signing will be strict.
आइए till the next date, the final decree shall not be sealed or signed without leave of this court.
Item number 30.
Okay, 30 तो होगा. 30 नहीं करा. 30 जाएंगे. Yes.
Item number 30 can pass.
All right, pass over. Sitik था. क्या तरह अच्छी order 41? Order 41, 37 interest. Taपर hearing. We'll take up second. Your matter, Mr. Mahathi, which item? 36. We'll take it up after recess.
interim bail. Your lordship granted interim bail for a period of 2 months and they have got married. And the brother's marriage is fixed to 14. Lordship. Some days extension.
It is submitted that the petitioner and the victim have married in the, I got special note, special will. It is submitted that the petitioner and the victim have married in the meantime. Further, the marriage of the petitioner's brother is scheduled to be held on
14/7.
on 14/7/2024. As such, it is prayed that the interim bail granted earlier be extended. Considering the submission.
On the next date, I shall put the proof of that marriage.
ସେଟା ଇଏ କର
ଖାଲି ମନ୍ଦିର ଲେଖି ଦେଇଛନ୍ତି କିଛି
ନା ନା ମନ୍ଦିରରେ ସବୁ ଡକ୍ୟୁମେଣ୍ଟ ଅଛି ମୁଁ ଦେଇଦେବି
ହଁ ସେ ଦେଇଥାନ୍ତେ ନା ଏଥିରେ ଆମେ ଦେଖଥାନ୍ତେ ଫଟୋ ଆଟଲିଷ୍ଟ ଫଟୋଗ୍ରାଫ ଦେଇଥିଲେ ବି ଆମେ
All considering the submissions and the grounds on which the extension of interim bail is made, I am inclined to take a lenient view. The interim bail granted earlier is extended by a further period of 1 month. The petitioner shall adduce proof of such marriage.
Yes.
Copy in course of it.
Urgent certified copy in course of the day.
Oblige.
Item 30 type of thing.
Item number 30.
The defendant, legal heirs of the original defendant are before your lordship.
Confirming.
Confirming. Suit for partition. Plaintiff filed a suit on the basis of a document that there was a partition deed among the brothers. So the defendants have no share in the same. In the written statement.
Who are the defendants?
Defendant are brothers.
Brothers.
Brothers. He says it is exclusively my property. In a partition suit, partition among the forefathers, the property fell to my share. So my brothers have no right over the property.
Okay.
I filed my written.
So why not a suit for title? Why a suit for partition?
Yes, that is one of my grounds. Second is, my lord, they relied upon a document saying that it's a deed of partition. I filed my written statement stating that it is compulsory to be registered under section 17 of the registration act. Having not been registered. Na, partition deed କହୁଛନ୍ତି ତାଙ୍କ ଭିତରେ ଆପୋଷିକ ପାରିବାରିକ
ଏଇଟା କଣ ରେଜିଷ୍ଟ୍ରେସନ ହବ
ସାର୍ ଯଦି ଟାଇଟଲ ଟା ଟ୍ରାନ୍ସଫର
କନଭେ ହେଉଥିବ ସେଇଥିରେ ତ ଟାଇଟଲ ଟା କନଭେ ହଉନି ନା
ସାର୍ ସେଇଠାରେ ସେ କହୁଛି ଯେ ମୋର
further on that basis they'll have to apply before the OLR authorities under section 19 ତ
yes
19 or whatever 19 ରେ apply କଲା ପରେ then only the title will pass.
ନାଇଁ ସାର୍
they agreed to submit an application before.
No, that was not written. ଆଜି ଦିନ ବଣ୍ଟନ କଲୁ. If it is today, if they acknowledge a previous partition, then registration is not, the registration of the document is not required.
Okay.
If they want to do it.
But no such issue has been framed. I was just looking at the issue.
Yes, no such issue has been.
Was it taken? Was the government?
Yes, I have taken in the first appeal. First appeal, your lordship.
No, what about your written statement before the trial court?
Your lordship may see page 23, paragraph.
I will, but please answer my question.
I have taken that point.
Specific point.
Yes.
But no issue was framed.
No issue was framed. But
you should have challenged it, or you should have filed an application for framing of an additional issue.
That was not filed, man.
I just want to know. You are obviously not the lawyer there.
Yes, he should have filed. He should have felt that should be an additional issue.
Yes.
And that point was raised in first appeal.
Let us see how he has dealt with it.
Yes.
So what happened to the trial court? What they were
Decreed suit for decreed grant
by holding that
He did not answer that. That was raised in first appeal.
Okay. Let us see.
First appeal, page 23.
Page 23.
Paragraph 12.
Yes.
The provision of section 17 of the Registration Act really enlists the document for which registration is compulsory, and clause B of the said provision mentions that other non-testamentary instruments which purport to create, declare, assign, limit or extinguish, whether in present or in future, any right, title or contingent, if the value of 100 rupees and upwards, or to the or in immovable property, hence in this case, no
In this
document-
case.
My lord.
Here in this case.
Here in this case, since no document filed by the parties to the case as to same was prepared for family settlement, just oral settlement question of registering the same as per section 17B of the registration.
He doesn't make any mention of that, any deed.
He relies upon in the plain their deed, but he does not produce. I raise the point that there is no partition, and if it is partition, then it has to be registered. He doesn't produce the deed and gets the partition.
No, I think.
And that is my question of law.
No, I thought there was some document, but
No.
he says there is a oral partition. Oral partition and registration kahan ho?
No, oral partition, my lord, I don't dispute. I dispute that there is no partition. I don't dispute that. I dispute there is no
No,
partition.
so Mr. Bose, the plaintiff says that there is a deed.
Yes,
He does not produce the deed.
does not.
So it goes out of the equation.
Yes.
Now, the only thing that can be considered by the court is oral sale. I mean,
My lord, can he do so? Once he relies upon, he says that there is a document and he doesn't produce it. And that point is being urged.
no, I will have to see the LCR.
Yes,
Let me call for the LCR.
yes.
After hearing learned counsel for the appellant, this court deems it proper to peruse the pleadings of the parties for which LCR is necessary.
Well.
LCR be called for. List this matter for admission in the week commencing 29 July.
My lord, I have filed two miscases, one for injunction and one for staying the final.
Final is the final decree. I'll say that
Final decree may proceed.
final
sealing
decree
and sign.
IRA, jota 248 of 2024. The final decree proceeding may
That is
continue.
FD 69 of 2013.
But the decree shall not be sealed and signed till the next date.
First, your lordship is posting to first week of August.
No, 29th of, in the week commencing 29th.
Yes, ma'am. Yes,
Then I'll see if I am satisfied, then I will admit, otherwise.
yes. It.
Item 31.
Your lordship, I'm seeking an adjournment as my senior Mr. Nkesau is not well, your lordship.
So why don't you prepare? You are arguing cases. You should seize this, grab this opportunity. This is a second appeal. Try to convince the court that there is some material in it to be admitted.
Your lordship, in that case, the matter may be taken up next week.
Next week. All right, next week I swear for.
Next, 15th.
Week commencing 15 July.
Obliged.
Item number 32.
Item number 32, I have got the respondent who is the caveator. But they have not supplied me copy of this.
All right, none appears for the appellants at the time of call. The counsel for the caveator is present. List this matter in the week commencing 22nd July.
Item number 34.
Maybe directed for supplying copy of the
IA. IA they must have supplied. They have not
They have
supplied.
not supplied.
All right, copy of the IA. The copy of the IA we served upon the caveator. Not appeal में. Appeal में admission होगा कि ना होगा देखा जाओ. You have no role to play in the admission. Yes.
May I please, your lordship?
Item 34.
May I please, your lordship? Here, my lord, this appeal is against the confirming judgment and decree of the lower appellate court, my lord. The fact of case is that the appellants were the defendants before the trial court and
You are the defendants.
my lord,
So it's a confirming judgment.
my lord,
Suit for?
my lord, suit for declaration of right title interest, permanent injunction and mandatory injunction, my lord. The plaintiff case is that, my lord, the suit land was originally recorded in the name of ex-landlord. The said ex-landlord executed a unregistered hatpata in favor of one Renuka Mohanty.
This is from Bhadrak.
My
Amal Nama Patta Joda Kundi.
my lord.
ସେ ଆଜି ବି ଖୋଜିଲେ 1932 ମସିହାରେ ଗୋଟେ ବାହାରି ପଡିବ। ସେ ତକିଆ ତଳେ ଇଏ କରି ତାକୁ ମୋଡାମୋଡି କରିକି ତାପରେ ଏମିତି ଥାକେ ବହି ତଳେ ଏମିତି ସବୁ ଥାଏ। ସେଟା କାଗଜଟା ବାହାରିବ ସେଇଥିରେ ଅମଳନାମା ପଟା ଲେଖା ହାତ ପଟା। ମୁଁ ଚାକିରି ଆରମ୍ଭ କର ବାଲେଶ୍ୱରରୁ ମୁଁ ଜାଣିନି। କୁହନ୍ତୁ। ଅମଳନାମା ପଟା ମିଷ୍ଟର ମହାନ୍ତି must be well aware of it. ଡକୁମେଣ୍ଟ ତାକୁ ପୁଣି ମାଟିରେ ଘଷିକି ତାକୁ ପୁଣି କରିଦିଆଯିବ ଯେମିତି 100 ବର୍ଷର ପୁରୁଣା ଦେଖାଯିବ। ତା ଦେହରେ ଲେଖା ହବ ହାତ ପଟା ମୁଁ ତମକୁ ଦେଇଦେଲି। ସେଟା ପୁଣି ଟେନାଣ୍ଟ ଲେଜରରେ ପଶିବ।
The said ex-landlord issued a hatpata, unregistered hatpata, in favor of one Renuka Mohanty for homestead purpose in the year 1944. In the year 1985, the husband of the Renuka Mohanty registered a gift deed in favor of the plaintiff in the 1985. Before the 1985,
You are the plaintiff.
no matter, I am the defendant.
You are the defendant. That's
My, in the before the gift deed, my lord, the HAL settlement operation came into force 1982, my lord. And in the year 1982, TL was opened in favor of Renuka Mohanty. The hatpata was issued in favor of Renuka Mohanty 44. TL was opened in the year 1982, my lord. And on the basis of gift deed, TL and hatpata, the plaintiff filed a suit for declaration of right title interest, my lord. As well, on the ground that defendant is an adjacent owner, he constructed a building on the suit land. In the said suit, defendant filed a written statement along with counterclaim stating that no, this suit land is the ancestral property of the defendant, my lord, and defendant also filed a revisional settlement ROR, CS ROR, but in the HAL settlement operation, it was wrongly recorded in the name of Renuka Mohanty. In the counterclaim, the defendant stated that the cancellation of the gift deed and the set aside the HAL settlement ROR. The trial court, without considering the TL and hatpata, he decreed the suit in favor of the plaintiff, my lord.
Let us see the issues.
The trial court judgment is Annexure 1. Issues are, my lord.
It is barred by limitation, counterclaim.
Issues number 10, my lord. Whether plaintiff is entitled to the relief for declaration of right title interest and confirmation of possession. Then issues number 11, whether plaintiff is entitled to relief of permanent injunction. 12, whether plaintiff is entitled to relief of mandatory injunction. Thereafter, issue number 13, whether MSROR bearing khata number 654 of Mauja, Ramakrishnapur and registered gift deed number such and such are wrong, illegal and void, my lord. If your lordships kindly see the finding of the trial court, my lord. I am placing, my lord, that is page 55, my lord.
Yeah, just one. Page 55.
My lord.
Running page.
My lord.
Yes.
My lord, sorry, my lord, page 50, my lord. First initial, page 55. Second paragraph. Exhibit 17 and Exhibit 18 is hatpata and tenant ledger. It is pertinent to mention here that though Exhibit 17 and Exhibit 18, the
through Exhibit 17 and 18.
My lord, sorry. Through Exhibit 17 and 18, plaintiff has claimed his title for the plot number 1834, but both the Exhibit 17 and 18 are created documents, are not according to law. With regard to hatpata, that is Exhibit 17, it is clearly visible when ex-landlord Sushila Bala Dasi had printed pata, that is Exhibit H, because she had no knowledge of Odia writing as she was Bengali. She signed in Bengali. If there will be a comparison in between Exhibit 17, Exhibit G and Exhibit 17 is a manufacture for the purpose of suit. Not only that, but also for the purpose of homestead lease cannot be granted under unregistered pata. So registration is compulsory. Assuming for the sake of argument, the ex-landlord for the purpose of agriculture unregistered lease can be granted, but after reclamation of lease hold into cultivable land, there is no pleading for homestead registration is necessary. There is not a single rent receipt issued by the landlord in favor of vendor of the plaintiff. Not only that, but also Exhibit 17 has not been proved properly according to law. Content of the averments has not been proved by the plaintiff. It is also out of place to mention here that at the time of issue of so-called Hatpata, PW1 was not born. So also he had not knowledge with regard to Hatpata. Exhibit 17 has disclosed Hatpata, that is 21-10-1944, whereas Exhibit 18 had disclosed Hatpata on 3-11-1944. So it clear Exhibit 18 is a fabricated document. Next question come with regard to the tenant ledger. During the time of hearing of the original suit, the plaintiff has procured estate vested on 1-1-1946, whereas the TL was opened in the year 1983, basing upon the MSRR published in the year 1982 in the name of Renuka. MSRR for the suit land is not corrected as it was prepared basing on the Hatpata Exhibit H, because the flow of title for the suit land by Renuka Mahanti does not arise. Renuka Mahanti is a lady. She was not competent to obtain a lease for agriculture purpose. To that Renuka was cultivating suit land. There is no pleading evidence. When her husband was alive, so also she was not settled right of that village. The ex-landlord usually grants lease to a permanent inhabitants of the concerned Mauja. Renuka is a wife of.
So it disbelieves both Exhibit 18 and 17, 17 and 18.
17, 18, my lord.
So how does he decree the suit then?
My lord, decreed the suit on the ground that defendant could not prove that regarding the right title interest of the.
So defendant's counterclaim should have been dismissed.
But here the plaintiff has not, when the burden of proof lies on the plaintiff.
Obviously.
My lord. So when the plaintiff has not proved his case.
So that I am asking you, Exhibit 17 or 18, jadi the court disbelieved for reasons indicated in that paragraph. So on what basis the suit was decreed? On what basis the title of the plaintiff was declared?
My lord.
Forget about your counterclaim for a moment.
My lord.
So how on what is the finding? Tell me.
My lord. If your lordships kindly see the page 55, my lord. Carefully peruse the case record, the documents relied by both the parties, arguments submitted by both the parties, evidence disposed of in this suit. Admittedly, the suit land in both suit and counterclaim was recorded in the name of Renuka Mahanti, wife of Ramachandra Mahanti, in Exhibit 1 and Exhibit A, which is published since 19.
Just wait. He believes the gift deed and also the possession.
My lord, gift deed.
He relies upon the gift deed.
My lord, only gift deed, my lord. When the.
So he doesn't go into the aspect of the antecedent title.
My lord. Yeah,
all right.
The appellate court also confirming their judgment.
Let us see the appellate court judgment.
My lord. The finding of the lower appellate court, that is, my lord, page 89. Undisputedly, undisputedly the suit property is not agricultural property. The plaintiff PW1 has deposed in paragraph 25 that in his plaint he has relied upon the tenancy ledger. The tenancy ledger was opened in the name of Renuka Dei in the year 1944, my lord. But where the tenant ledger was opened?
1982.
82, my lord. The tenancy ledger was opened as per the CS relation.
You know, where did you get this? That it was opened in the year 1944?
My lord, as per the averments of the plaintiff, my lord. My lord, six kindly. My lord, is permitted me to place the plaint of the.
Where is the mistake then?
When the plaintiff has not proved the right title interest over.
Plaintiff bases his case on the gift deed, Exhibit 16.
Exhibit 16, my lord. But
So you have never challenged that gift deed. You could not rebut that evidence.
My lord, I have challenged that gift deed.
No, challenging it means challenged it by way of a suit at the relevant time. Say 85 re itla gift deed ta.
My lord, 85 when I came to knowledge about the gift deed, my lord.
So did you file any suit?
My lord, I filed the counterclaim and stating that gift deed is not that the gift deed is a void deed.
So how could you prove it? What proof did you adduce? What was the rebuttal evidence?
Rebuttal evidence, my lord, that when the plaintiff's vendor has no right title interest, then the how the plaintiff got the
antecedent title.
My.
You're referring to the antecedent title.
My.
All right. I'll have counsel for the appellants. Peruse the impugned judgments. Considering the submissions and the ground on which the grounds raised in the appeal, the grounds raised, the second appeal is admitted on the following substantial question of law: whether the courts below were justified in declaring the title of the plaintiff over the suit land when his antecedent title was not validly proved. That's all. An antecedent title ta bhalo kore prove hoyni kintu tame title ta kintu prove. Now what about your counter claim? That will take care of everything. So tenant ledger hala ki accepting the unregistered lease deed hathpata and all that, though they will be covered by this. In trying to prove his antecedent title, he relies upon the hathpata and the tenant ledger. So say the coverage only. Issue notice to the respondent by registered post with AD fixing no, sorry, 4 weeks. Returnable within 4 weeks. Requisites be filed within 3 working days. LCR be called for. List this matter on August.
In the week commencing 27.
In the week commencing.
IA for stay of execution proceeding.
IA. Oh, good. There shall be stay of further proceedings in execution case. Right, CMA number 10 of 2023. Pending in the Court of Learned Civil Judge, Senior Division Bhadrak, shall remain stayed till the next date.
Item 35.
Yes.
But the defendant is in appeal, reversing judgment. London trial court dismissed the suit. Plaintiff filed appeal. Appellate court reversed it. Suit for declaration of a deed of gift as null and void and other consequences.
Well,
But the
gift deed. Plaintiff relied upon a gift deed.
plaintiff filed the suit for a declaration that the deed of gift.
Oh, okay. Is void. So deed ki মানে gift টা কি কাজ করতে?
Plaintiff executed the gift in favor of her nephew, means husband's brother's son.
Putra.
Putra.
And who are you?
I am that Putra.
Acha, you are the Putra. So in your favor it was executed. Then?
In fact, the plaintiff's case is that plaintiff is the second wife of her husband. After death of first wife, husband married for the second time. Husband had two sons. One of them is dead. Other is remaining outside. So in order to maintain the property for day-to-day maintenance and to take her care, this defendant, who normally a Calcutta resident, was brought by the plaintiff herself to Jharsuguda and he started residing there with the plaintiff. Now, in course of time, the plaintiff initially executed a will, registered deed of will in favor of the defendant. That is will dated 31st of October 2007. Now, after executing the will, she again executed a deed of gift. That is Exhibit A, 5/11/2007.
Which is the subject matter of the suit.
Right. That deed was a registered document. And after execution of the gift, almost 2 years thereafter, she revoked the will. She executed a deed of cancellation of gift.
Cancellation of the gift.
My lords know the registered deed of gift, once title passes, by cancellation, it has no effect at all. Title will never come back. That's the settled position of law. Cancellation of gift deed never reverts back the title. So that is the reason probably she filed the suit for declaration of the registered gift deed of gift as void. On what ground? She takes a ground that yes, I have executed the will. Yes, I have executed the deed of gift, but I am an illiterate lady. I only know how to put my signature. My signature was taken on a blank stamp paper.
Is that Karbuja Queer? Karbuja Queer, that Privy Council decision?
Yes. That illiterate is the one.
That's 63 Super.
Yes. Organization lady, special clock of protection. Special clock of protection. So she took this plea that it is my blank paper and signature. I only know how to sign. So the gift is fraudulent, fraud, we declared as one.
The only thing is that the burden is cast heavy on the defendant,
provided
on the beneficiary.
Provided she is illiterate.
So that has to be, that foundational evidence has to be added.
Yes. Now the gift deed, if your lordship sees, she has signed in English. If the deed of gift is drafted in English, she has signed in English. That is one. Two, the trial court dismissed the suit with issue number 3, 4 and 5, with 3, 5 and 7, with a specific finding that the allegation of fraud are not specifically pleaded in the plaintiff. As your lordship knows, Order 6, Rule 4. If you are making allegation of fraud, you will have to, unlike normal pleading, particulars of fraud has to be pleaded. That kind of pleading is not available. Trial court primarily on that ground dismissed the suit. Now, when it went to the appeal, appellate court precisely on 2 grounds allowed the appeal, saying that that deed of gift, which is executed by the plaintiff, though was attested by 2 witnesses, but none of the attesting witnesses are not examined. 1, 2, illiterate Pardhanashin lady, as your lordship is saying, all the judgments has been reproduced in the judgment and reversed the finding. But I have only 2 points here. If your lordship sees, that lady not only has signed the gift, it's on fact also, of course, but section 68 of the Evidence Act, when it is a registered deed, attesting witness examination is not necessary. So that part of the finding given by the trial appellate court is wrong, completely wrong. 1, 2, as to illiteracy, not only she has signed the deed of gift in English, She has signed her deposition in the court in English. So if the appellate court would have at least seen her evidence or affidavit, which she has signed in English, it can't be said that she is not able to read and write. So these factual aspects, but I have taken those grounds in appeal.
Is it 1 and 2?
Correct.
Heard Sri Professor Kumar Atharva and senior counsel with
Mr. Dhiren Kumar Mahapatra.
Mr. D.K. Mahapatra, general counsel for the appellant. Appellant? No?
Appellate.
Appellant. Peruse the impugned judgments. Considering the submissions and the ground taken, the second appeal is admitted on the following substantial questions of law. Page 6 of the appeal memo. I or II. These two are sufficient.
That will do.
Issue notice to the respondent by registered post with AD, returnable within 4 weeks, requisites be filed within 3 working days. Call for the LCR. List this matter in the week commencing August.
Right.
20th August. Are you?
Not injunction I have said because they will be trying to correct the ROR, then disturb my position. I am in position on the basis of the gift. Reversing judgment.
Let's notice as above. Look on the notice as above. Considering the submissions, it is directed that till the next date, no order correcting the ROR in respect of the suit property shall be passed without obtaining leave of the court.
And status quo be maintained by.
Further, status quo as on date shall be maintained with regard to the suit property.
Great.
Item 36.
Here is a peculiar case. Suit for partition was decreed.
Suit for partition was
Suit for
you are who are
and the
you?
legal errors of defendant 1.
Defendant 1. Yes.
Suit for partition was decreed. The defendant 1 was granted 1/3 share in suit property, as like plaintiffs and other defendants have got their share. Nobody challenged the preliminary decree. So the determination of share is confirmed. Plaintiff filed final decree proceeding. In the final decree proceeding, plaintiff filed a petition for appointment of civil court commissioner. Civil court commissioner submitted a report. I filed my objection on 29/11/2008. It has been referred in the trial court's order. Trial court order starts from page 29. Page 29. I have got certified copy of my objection. Kindly email. Page 29 is the trial court's order. My objection, para 7, 8, and 9. I have specifically objected that the property sold by plaintiff, possessed by the purchasers, has been allotted in my favor. The property possessed by plaintiff has been allotted in my favor. The property possessed by the defendant 1 has been allotted to somebody. 7, para 7, 8, and 9. Kindly see the order. Order starts from page 29, trial court's order. Acceptance of civil court commission. Page 29 is the cost item. Page 30 is the facts. What is the suit for partition?
1/3 each.
1/3 each. Now kindly come to page 31.
Yes.
Objection of OP number 6 has been considered. Objection of 4 and 5 has been considered. Objection, specific objection of defendant 1 has not been considered. Kindly see last page, page 32. Now the civil court commission has been accepted. I challenge that my specific objection has not been considered. Order pass kale. Objection refer bhi kalen. C haba आगे B B और C haba yes.
C टा ହେଇଗଲା ହେଇଗଲା.
हाँ CL haba.
If your contention is accepted.
Aye.
What will be the result? It will be remanded.
It will remanded.
So on the issue
Seat will be remand hobo.
Seat hello.
Aye.
Or Sri Maheshwar Manthi. Then counsel for the appellant. There will be implement judgment. ये और तो कर दो, है ना? ना notice पर इसको जाके कर दो. आइए रे खाली करो. We'll say that final procedure.
Stay of seal and sign finally.
In आइए रे करो. The final decree proceeding shall continue.
Seal and sign.
But the decree shall not be sealed and signed till the next date.
A requisite 1 week time.
20? No.
LCR
to call for he. Some say all right. This matter in the week commencing 20th August.
पक्ष अधिक आचरण 1 week time.
All right. Requisites within 1 week.
Right. Urgent copy.
Urgent certified copy be granted.
Item 37.
See age study हो. मुझे दिल्ली additional age study के especially.
कहीं age का कौन रखा है? ऐसा तो allotment ऊपर ऊपर जाती है जे ये पोजेस करछन ना करो सीधे पोजीशन
objection करछन
कौन रखा है हमर तो objection अछि ना
এটা ঠিক নেক্সট উইক রে হবে স্যার
yes
নেক্সট উইক রে
এটা চান্স আছে alright this matter 15 July in the week commencing 15 July
স্যার নেক্সট উইক রে কত মু কত প্লেস অ্যাডমিশনটা তো মু পড়িনি
next week here alright next week alright
Item 39.
38 age.
39 and for the appellant, probably respondent is appearing lands.
Item 38 Milord Sai. I was not.
Item 38 कौन है?
15th July.
15 July.
I was not being intimated Milord Sai.
39 Mr. Prahlad Kara is appearing for the respondent. I am for the appellant.
Prahlad Kara अछंती?
नहीं ताको जिन
आपण कहले प्रहलाद करा appearing बोली?
Let's was up.
प्रहलाद करा टीम तो तू कैसे appear करियो?
Sorry your lords.
नहीं is it being conducted by Mr. Gurudatta Kara?
Yes sir.
Then I will not hear. I am concerned.
That is.
I'm concerned. List this matter before any other bench with kind permission of Hon'Ble the Chief Justice as I am concerned.
Item 40.
Who is the other side, Mr. Manthi?
Senior is
Ki senior?
on behalf of SC Mahapatra, Disengagement.
अच्छा ଆସିବେ ତାଙ୍କୁ ଡାକ ଆରମ୍ଭ ପାସଓଭର ହବନି 2003 ମସିହା ମାତ୍ର ଡାକିବା ପାଇଁ ଡାକନ୍ତୁ ସେ ଆସିବେ ଆଉ କଣ ଇଏ କରୁଥିଲେ ଆପଣ ବସିକି ନୋଟ୍ କରନ୍ତୁ ନୋଟ୍ କରନ୍ତୁ 2003 ମସିହା ମାତ୍ର ଖସିଗଲା ହାତରୁ ଖସିଯିବ LCR is there? Yes.
And there is this genealogy is for appreciation of the case only.
Substantial question of law ta dekhte.
The dispute relates to
the substantial question of law as enumerated in para 2A. Para 2A re kon कहले? Question of law. Yes. Well, what is this? Who are you?
I am the defendant in the suit. The suit was dismissed. Thereafter, in appeal, it has been reversed.
Suit was for declaration.
Suit was for declaration of title, and that too for restraining the defendant, preventing him from disturbing the possession of a well. The disputed property is only a well. 4 feet into 4 feet, depth is 40 feet. Now,
I have seen disputes with even less land.
Yes.
And that too between persons aged on one side about 95, the other side aged about 92 years. Total passage gote chotia latrine achi setପାଇଁ they were fighting litigation for more than 50 years. Strange are the ways of human beings.
Here, in fact, the dispute remains as to the user of the well. But
So why title is required then?
that is exactly the issue. That is the reason the suit was dismissed. Learned trial court, even if it is admitted and a document was exhibited, exhibit 2, which is a document of partition, where the property was specifically allotted to the Balabhadra, the defendant's predecessor.
So this is a matter between dispute between the members of the same family.
Same family. One branch is Balabhadra, plaintiff's branch is Jagannath.
Achha.
There
They
is
belong to the Ramachandra branch.
plaintiffs belong to Jagannath.
No.
Yes, Rab. Then defendant is the Balabhadra's branch.
Yes.
The property fell to the share of Balabhadra in a registered deed of partition. That is exhibit 2.
Item view. Item 42. Exhibit 2. List of exhibits.
Exhibit 2 is
Sir, पुणी से प्रॉब्लम होगा अपन मतलब सर्टिफिकेट कॉपी जो रखते दे दो तो मैं देखि देबी नहीं कॉल दिन तब
देखिया दरकार हो कारण लैंग्वेज ऑफ द
आपन पाखे आ नाही
मु कहि कर दे जो फ्लैग मार्क कर से प कछ बोली गोटे
एटा की दिस इज व्हाट इज दिस डॉक्यूमेंट लेट अस सी
रजिस्टर्ड डीड ऑफ पार्टीशन
हाउ हैज इट बीन डिस्क्राइब्ड पक्ष मान को नाम धाम से बड़भद्र इत्यादि इत्यादि की प्रकार दलील बंटन पत्र ठीक अछि
प कछ प कछ तो सेही पेज रो आरंभ छै हां बिलो देयर आर सर्टेन लाइन
क ओ ख मुताबिक गोटिए कछ करी आम मानक मध्यरे बंटन करी देइथिबारु आमे माने आपोस रे आज को 20 वर्ष हेबो
रखी पारनी
आमे पक्ष माने आम मानक तफसिल कछ मुताबिक घर बारी स्थिति रे पृथक भाबे मालिक दखल करा नबो
मोर टिक मार्क करछि क कछ सेउठु इनफैक्ट आरंभ होछि बळभद्रଙ୍କ अलॉटमेंट
मु देखि दउ तपर आपण पढि देबे
सर
पूर्व आम मानक मध्य बंटन होइतिबा तफसिल क चिन्हित कछ यो 15 डेसिमल 5 कोड़ी एथिरे विद्यमान थिबा पुरातन पक्का कूप देखो गोटी पुरातन आटू घर बा खरा खाई छपर घर
काई छपर
काई छपर खरा कबर चौकाठ सहित आम मूल्य 1500 टंका आंभे प्रथम पक्ष बलभद्र साहू कच्छ संपत्ति घर बारी कृति अटे
नेक्स्ट पेज रे यूजर टच यूजर राइट
जगन्नाथ साहू तांकर उत्तराधिकारी माने पुरुषानुक्रमे उक्त कूपर दक्षिण तरफ चांदिनी रे प्रवेश करी जल व्यवहार करिवार अधिकार रहिला जे आंबे प्रथम पक्ष बलभद्र साहू आम उत्तराधिकारी माने जगन्नाथ साहू तांकर उत्तराधिकारी मानकु उक्त कूपर पानी व्यवहार करिवा अधिकार वंचित करि परिबु नाही कि परिबे नाही करले हेले फौजदारी गला
that is the document itself is evidence that the property fell to the share of this branch of Balabhadra, but the right of user of the well remained with the Jagannath also.
This is exhibit
2.
So Jagannath had right of user.
User. This document is admitted because plaintiff claims his right on the basis of this document. Now, in spite of the fact a right of user was given under the document, a claim was made for declaration of right title interest. The learned trial court dismissed that, saying that right title interest cannot be declared, it is only the user's right. Now, kindly have a glance at the appellate court judgment.
First appellate court is subject.
Right. First appellate court,
Subject. Yes.
senior regional bench.
ସେଟା ହଉଥିଲା ନା?
ହଁ। ସେଟା paragraph 9, page 13. The sentence beginning with Sri Swain, the landed counsel for the appellant. I am just placing that. Sri Swain, landed counsel for the appellant, submitted that from the terms of Exhibit 2, it is well evident that the appellant has joint right and ownership over the suit well, but the landed court below has failed to appreciate the evidence adduced.
Joint right and ownership bill.
Yes, the claim is right and ownership, but that is not there in the document. Because the suit, because here the plaintiff was the appellant here, that same claim was being repeated over the suit well. But the landed court below has failed to appreciate the evidence adduced by the plaintiff to that effect. Incorrect perspective. On the other hand, Sri Mishra, the landed counsel for the respondent, submitted that the defendant has exclusive right and ownership over the suit well, as it finds mentioned explicitly in the Kacha allotted to the share of the late father in Exhibit 2. On close perusal of Exhibit 2, as it appears, the terms thereof are clear and unambiguous to the effect that suit plot, along with the well in question situated therein, finds mention in Kacha of the deed of partition, which has been allotted to the share of late Balabhadra. It is also stipulated therein that the original plaintiff number 1 will use the water of the suit well as of right for all times to come and from generation to generation without any hindrance from the side of Balabhadra or its successors. Successors in interest in any manner. That apart, both the brothers were would jointly remove, renovate and repair the suit well from time to time. Cost whereof will be borne by them jointly. Thus, it would be ridiculous that late Balabhadra had acquired exclusive right over the suit well. Merely because the well situated over plot number 275, which stood allotted to the share in Exhibit 2. Right to use water of the suit well is a right inherent with the concept of ownership of property.
Okay.
In question, to add to it, whether joint right to use water is annexed, the corresponding duty and obligation of the co-sharer, that is plaintiff number 1, with regard to repairing and renovation of the suit well will jointly with the late Balabhadra, read with the fact that the well in question is the ancestral will of the parties. I am of the considered opinion that from the recitals of Exhibit 2, the exclusive ownership of late father of defendants over the suit well is not established. This is completely erroneous against the document itself, because the grant is only in respect of user of the well. Here, he has termed it as if the right of the ownership has also been allotted in favor of the. Rather, as it is established thereon, both Balabhadra and Jagannatha had joint right and ownership over the suit well. Even though the well situates over the land allotted to the exclusive Kacha of Balabhadra. Of course, then it continues again the same. The next page, one line is there, para commences, no doubt.
Yes.
No doubt, argument was canvassed from both sides, and the landed court below has also referred to the impugned judgment about the alleged right of easement acquired by the plaintiff so as to use the water of the well, suit well. But in my considered opinion, the concept of easementary right of the plaintiff vis-a-vis the suit well cannot be attracted, much less established from the recitals of Exhibit 2. This is one type of easement, but it can be termed as easement by grant, because under a document, not by a user. Maybe section 17 or by that. But here he said, even though it has been granted under the document, no user, this cannot be treated as a easement right. Next page, again, he has reiterated the same. Next page, page 16, Thus, I conclude that the learned court bill has erred in holding that the suit will exclusively belong to the defendant and the plaintiff have no right title in interest over the suit will. Although it is well evident that both the said brothers have joint right and ownership over the suit will, as I have already indicated above. This is the only question. And the user right that has been restricted also. Learned Appellate Court has taken into consideration that, saying that because it's a rain scarcity area, the water cannot be used in such a manner to extract the entirely to dry up the. That observation is there. It is impracticable during user because the dispute arose when a jet electric pump was fitted in the well. Everything has started. That was the cause of action also. Now, while deciding this question, in spite of the document, even admitted document of partition of the property, the ownership has been declared. My submission is this conclusion is wrong. Yes, right of user of there. The whatever has been observed with the appellate court, both parties will abide by that also. That observation is there. So kindly come to page 21. Manner of user is indicated. Page 21, third line, of course. The sentence beginning with of course.
Page 21.
From the top, third line, course. Of course, while drawing water from the sewer well, though pipeline fitted with electric motor, it is obligatory on the part of the plaintiff appellant to give due regard to the water level the existing then existing in the well at the particular time of use of the electric motor by him. The appellant cannot exercise his right to use water of the well in the above process so as to cause inconvenience to the defendant respondent. In other words, the exercise of such right by the plaintiff appellant cannot be detrimental to the interest of the defendants. Some observations there, not to completely destroy the water level and to use the same with much caution. So there is no dispute so far as I don't have any grievance so far as this aspect of the matter is concerned. But the ultimate conclusion that the property, the plaintiff has the right title, interest and ownership of the property, that is illegal because it's contrary to the document exhibit 2. That's all.
Yes, Mr. Mahapatra. Prepare nothing. All right, heard in part.
Nice.
Is this matter next week?
Right.
Hearing about part upper all right. Next week it will come. Sorry, is it small matter?
Perhaps by afflux of time, so far as the relief claim in the well, by afflux of time, the well must not be there. Parties are there and they have residential well.
Well is there. I have taken instruction because it has what I can pay or that is still there. That well is there.
We'll take it up next week.
And one thing my learned friends should know here, the well existence of well is may be there, may not be there. Yes. But the right to declare that is important.
Yes.
Item 41.
41. Yeah. Next week, 41, 45, 46. Prepare.
Release this matter in the week commencing 15 July.
41.
45, 46.
42 tarjon is
45, 46.
45, 46.
Item 43.
Item 43, your lordship, my senior is supposed to argue.
Where is he? If he is supposed to argue, then he is also supposed to be here.
Your lordship is on his legs. So, the matter may be.
Call him. Call him. Pass over.
Item 44.
Item number 44, my lord.
Yes.
I'm sorry, my lord. Suffering from viral fever for the last 4 days, my lord.
Yes.
So I could not get prepared. Can your lordship take it up after 1 week so that
Place this matter in the week commencing 15th July as prayed for.
Item 47.
47. None appears. Arjun.
22nd.
22nd, yes.
Item 48.
Who is opposing you, Mr. Satpathy?
option on the sir.
Anyway, let us begin.
Saraswati.
Aye?
Item 48.
Yes.
Because
Item 48.
because sir against a grievance line.
Aye?
The suit has been.
No, let us begin.
Okay.
Let us begin.
I'm giving a written note.
Yes.
Can I glance?
Let me just see the substantial question of law.
Substantial question of law.
Let me see.
Whether the lower appellate court has committed an error in holding that the appeal preferred by the defendant number 3, RFA number such and such, was hit by the principles of res judicata, since another appeal filed against the same judgment of the lower trial court by the plaintiff bearing RFA number such and such was already decided and confirming the judgment and decree of the lower trial court. Another substantial question of law is that whether the lower appellate court, by holding as above, has misdirected itself in not considering that the suit of the plaintiff was decreed in respect of 3 of the scheduled properties and not wholly, and the plaintiff filed RFA number such and such claiming for a full decree of the suit, but the legal heirs of the defendant number 3 as appellants in RFA number such and such challenge the finding of the lower trial court with regard to finding that the will executed in favor of the father of the original defendant number 2 was invalid. So the civil suit was filed claiming can I have glanced at my written note that only.
I written note again. Yes. What is the suit? Pick up
Okay.
From
Suit is for declaration of.
Who are you? Who are you?
I am the defendant number 3.
Defendant number 3.
Sorry, legalese.
Suit for?
Suit for declaration of right title interest. Suit to declare the sale deed executed by Chandravati Maji in favor of defendant 2, 3, 4, and 5 as void and not binding on the plaintiff to cancel the same, and to declare the registered will executed by Chandravati Maji in favor of my ancestor Parmeshwar Maji is illegal, void, and not binding on the plaintiff to recover possession of the suit land from the defendants, and the same may be given by deliberate possession of the plaintiffs through court.
Yes.
The suit schedule, I have page 3 of my written note.
Yes.
There are 6 scheduled properties. The common scheduled property is schedule A. B scheduled property is the a sale land made in favor of the defendant number 2. C scheduled land
2 and 4 will लिखाई 2 to 4
2 to 4 चारटा जो schedule है ची 4 जन sale deed हेतला. B scheduled land हेतला defendant 2 to 4 favor. तो C scheduled land defendant number 3 favor. D scheduled land defendant number 2 4 favor. E scheduled land defendant number 5 favor. Schedule F land on the basis and that covered in the will exhibit A. Should जेटला decree होला C schedule land and E schedule land which executed in favor of Mr. Bose's client declared as valid. That legal necessity has not been established by the plaintiff. That has been answered. That is valid. That against such denial of relief, the plaintiff filed appeal. That appeal has been decided that the trial court judgment with regard to the confirmation of sale deed is valid is confirmed. So far as the declaration made against the present appellant that the will is invalid and my status with relation to the original ancestor Bhimadhara is not correlated has been challenged in another appeal, in my appeal. What happened? There is a confusion created. Both the appeals is required to be had together. What happened? Our side and both the court side also could not both the appeals club together. The plaintiff's filed appeal, plaintiff's appeal has been decided. And that in relation to the confining to the whether sale deed in respect of C and D E property is valid or not. So far, my contention and my challenge to the validity of the will and to the relationship of myself along with the original ancestor Bimbadhara has not been considered. That is required to be considered in my opinion. In my appeal, when that has been decided in the 2011, without recording any contention, without giving any finding on my contention, the court straight jumped to the decision made by the principal of the res judicata, since the earlier judgment passed by the first appellate court confirmed the judgment of the lower court. That is the first question of law. And all the merits of the appeal has not been dealt with in the judgment.
That appellate court order confirming the judgment of the trial court has not been further challenged.
Further challenge.
Has not been further challenged.
No, not challenged. My instruction.
So whether it acts as a res judicata.
The first appellate court considered my appeal only on the technicality that since the lower appellate court judgment has been confirmed in the first decided case, therefore there is no scope for the appellate court to interfere on merits of my appeal. In my para 11, therefore what I have submitted, so for the claim of Mr. Bose's client, I have no objection. That salary is valid. My contention before the first appellate court and before this court also, the will executed in my favor is valid.
Fact. You have given a genealogy.
Genealogy valid. In this genealogy, Bimbadhara is the common ancestor.
Yes.
Bimbadhara has 3 sons as per our submission in written statement: Bhuja, Mara, and Jatia. And Mara had 1 son, Kandu, and Janaki. Janaki has 2 sons, plenty Mandara and Lakshmana. And Kandu wife is the Chandravati. And Jatia died as a son is the Gangadhar, who died as a issueless. Since the property of Kandu, I have claimed as a reversioner, and since I am the Parameshwara.
No, you are Parameshwara. So how can you alone claim it as a reversioner?
Because, my lord, both 3 are brothers. My contention before the trial court, Bhuja, Mara, and Jatia are 3 brothers. And Jatia's property came to the Bhuja and Mara. And Mara is since Mara died, living man Kandu and Janaki, and the property of Chandravati stopped there. Therefore, property of Chandravati Kandu came to my share as a son of branch of Bhuja.
So Chandravati is the wife of Kandu. So say it is Sarigala. Yes, Sarigala. Say it revert karibo?
Revert karibo.
If revert karibo, kaha par revert karibo?
Definitely question came to the Janaki. Janaki is the scheduled type of daughter of a scheduled type person. That is clear.
Janaki hele apan babu asibo.
Janaki baku na Mara baku ka naam baku. Janaki baku bolle.
I'm sorry, Mara. Mara babu bolle apan se jo Bhuja through re apan babu asibo. No, apan kemti claim korchu?
Bhuja through re claim korchu. Plaintiffs suit a trial court hold karle. We are not sufficiently established. Bhuja is the son of Bimbadhara and brother of Mara. Therefore, our plea of reversion has been negatived by the trial court. Chandravati has executed a will, by registered will, executed A, that is in my favor. On the basis of will, the property has been recorded in my name in the settlement record of rights. The will has been challenged by the plaintiff, saying that will is not valid. To that effect, to prove that will, I have examined 1 attesting witness. I have examined the scribe of the will. Though they have clearly disclosed before in their deposition, the will has been executed in their presence, and that is a registered will, but the trial court disbelieved the same. And the appellate court did not consider the merits of the appeal. My contention, since my appeal is not a res judicata to the earlier appeal, both the points raised in 2 appeals are different and relief claims are different. The first appellate court committed such an error, holding that this is a principles of res judicata has been applied. I have given a table, my lord, in my table. What is the difference between 2 appeals, my lord? Page 7 of written note.
Yes.
the first RFA number 42/78/2005 has been decided by the additional decision of Sundargarh, and first appeal number 43/34/2005. And subject matter of challenge in the first appeal, that part of the decree in refusing to declare the sale deed in respect of Schedule C and E property. In subject matter of challenge, in my appeal, the declaration made by the trial court with regard to the validity of the will under Exhibit A, alienation in respect of Schedule B and D property invalid, the finding with regard to the status of Bhujo as son of grandmother was challenged. Here the affected person in first appeal, defendant number 3 and 5. Here the affected person is the respondent number 1. My decision in my appeal no way affected to the defendant 3 and 5. My appeal is affected to the respondent number 1, means the plaintiff. Therefore, and decision in the first appeal, that is confined to the validity of the execution of sale deed C and respect C and D. There is no finding with regard to my status or with regard to validity of will. That is purely confined to that issue only. There is no decision in that in respect of my contention in my opinion. Therefore, the points are different, affected persons are different, challenge is also different. And this is not a suit, this is an appeal. Therefore, the court will, without considering the difference in two appeals, committed error, observing that is a hit by the principles of respect. That is something. If would have been considered on other part or merits of the case, that then point of different. None of the points on merits has been taken out of in the judgment. That is.
Yes, Mr. Bose. Lord, what I've heard from my learned friend is that he doesn't have any grievance against me. But as to assist the court, your lordship may kindly mark one thing. The properties of a family, the res judicata point which my learned friend is harping upon, that it will not be barred by res judicata, may not hold good. The reason is, my lord, maybe two suits may be two different reliefs, but the property being of the common hotspot, any finding on the entire issue is barred by res judicata in the other suit.
No, I stopped asking him. I forgot to ask him. Will it not be hit by the principle of constructive res judicata?
Correct. My lord is absolutely correct.
Well, the constructive res judicata means I have not preferred that appeal.
You may not have. You may not have. You have preferred appeal. That is what is slightly saving. What has happened is actually, well, I should not say so, but this is a mistake of the court. Both should have been clubbed together. This is precisely the reason why they have to be clubbed together.
Yes.
Otherwise, conflicting orders would not be passed.
That's right. Once there are two suits, inter-party suit, or some parties are more in one suit and less parties, but property is somewhat in same. We generally come up before your lordship either under section 10 in the code below or 151 CPC to club up both the suits. Or we pray that the original first suit may be decided first, second suit may be stayed till the first suit is decided.
Stay of suit the same.
Stay of the suit. Generally, the court holds that no, both the suit will be tagged up together and should be tried one after another. So that if the issues are common, there will be one set of evidence so that both the suits can be decided in the same way. Now, question is, my lord, once the properties of a common hotspot, and his claim is based that I derive a title from a particular branch, and that branch is involved in the other suit. May not be the relief may be same. Maybe the relief may be different. But the fundamental question is whether I get a title or not. Once I want to derive a title from a particular branch, one suit or one which has been confirmed in appeal will act as a constructive res judicata on another suit. Because that portion of finding has not been assailed before this honorable court in second appeal. Relief may be different, But the flow of title.
Can we not ask the first appellate court to rehear the appeal again?
Even if your lordship has the power to remand the matter, your lordship can even exercise power under order 41 rule 23. Your lordship can exercise power under order 41 rule 25 also. If
By framing an issue.
yes, if your lordship frames an issue, then your lordship will keep this appeal pending, direct the first appellate court to answer that issue. Let us hold for the moment your lordship is exercising power under order 41 rule 25. 23 is an open remand. 23 is
not hold good here.
If your lordship also exercise our power under order 41 rule 25, what will be the consequence? The consequence will be that judgment having not been assailed before a superior court, the finding will be same.
No, but the other part, the finding in his suit, his appeal.
The problem, he has 1 minute. Problem here is that there are two suits are different. The two suits but come to judgment, then question is different. But here suit is one.
Appeals are two.
So appeals are maybe that is generally what happens. I will give another example.
This is the mistake he has committed.
Yes, I give another example. In a suit, certain findings are in favor of the plaintiff. Certain findings are against the plaintiff. There are different issues. Certain suit is partly decreed. The defendant challenges those findings in favor of the plaintiff in a first appeal. The plaintiff challenges the findings against him in the another appeal. One appeal is dismissed, confirmed, and not challenged in superior court. But while deciding that appeal, the court below holds that the source of the title is not there.
So that is what I am saying. So since that appeal, the order in that appeal has not been challenged.
Yes.
So that is binding?
Yes.
And it is also not challenged before this court?
No.
So this court cannot ignore it.
Cannot.
Now, under such circumstances, what would happen to the, and there certain observations, as you say, have been made with regard to the source of the title and all that. They are obviously binding.
So even if once that source is binding, even if your lordship reminds the matter, that what my brother is saying, that it was not discussed on merit, it was only dismissed on the ground of res judicata. Will it hold good manner? Can the appellate court decide it? He has already decided.
So how to get out of this technical impasse? This is a technical impasse.
Technical impasse, but your lordship, while deciding in second appeal, has to also see the other aspect. Whether your lordship's remand can be answered.
Let's forget about the remand for a moment. How to decide this matter? When that particular matter stares at our face.
That is the point.
Isn't it?
Cannot do. It will be barred by constructive res judicata. 77 Supreme Court stares at him.
That is not applicable to this present.
No, you have tried to make out a case, Mr. Satpathy. I was just going through that tabular form you have tried to segregate. But then whatever findings have been given in that year, which have a bearing on your case also, how can it be ignored?
That is my submission. There is no bearing with my case.
So you should have also challenged that.
That is seems that the plaintiff's appeal decided touching to the point of the will, touching to the point of the my status, that would have been different.
No, how can you segregate it?
Well, segregate since
Where may be segregated?
Since two appeals has been filed.
The principle cannot be segregated.
Since two appeals has been filed, I have the appellate remedy and I have availed that remedy. And my contention of the appeal, my grounds of appeal, my relief is something is different than the issues are totally different. And if the court below came to the conclusion that this is a res judicata on the issue, then my merits of the grievance, my claim over the property is required to be examined in the second.
It may be, but that finding, it also has a material bearing on the outcome of
material. There is that judgment with me.
Let us hear it again in detail. Hear it in detail. Heard in part. Is this matter in the week commencing? Prepare. Oh, in the week commencing
Sir,
15th.
I school ରଖନ୍ତୁ ସେ week ଟା ଟିକେ ଏପଟ ସେପଟ ହେଇପାରେ ମଝିରେ ଛୁଟି ଅଛି ତ ମୁଁ ଟିକେ ନ ରହିପାରେ।
Oh, 22nd,
ଆଜ୍ଞା, ଆଜ୍ଞା।
22nd.
ମାନେ the thing my brother should have done, though I am not his advisor.
नहीं, but
He should have challenged that finding in a second appeal.
Yes.
And once he challenges that finding, his ground which he is arguing before your lordship now, that my appeal was not heard on merits, but it was dismissed on the ground of the adjudicator, your lordship have got a handle to remand both the matters for retrial.
that is why I am saying it would open up the entire
Yes.
situation. Now, only part of it I can only examine, the other part remaining here. Even if I hold that it is not by the adjudicator, I will go to the merits. On the merits, that finding will be there.
Well, that there is no such finding. देखो से जो judgment है, no such finding and my
Whether it will operate as adjudicator or not, can you please assist the court?
again.
We'll take it up in 22nd.
I have tried lot of my such as a judgment in case of 2 appeals. But 2 appeals, there is no
Site को देखी करिए बोलो ना.
Yeah. The court would below refer some judgments with arising out of read petition. Read petition, one judgment, the court below referred in the initial judgment, I have verified arising out of read petition.
We'll see.
Okay.
Yes.
Item 49.
22nd, week commencing 49, anybody?
54.
None appears.
154 item is there.
You're not reached. For them, I'll add them.
Interim order may be extended.
Interim order to continue.
Great. 54.
Item 49, none appears. Is this matter put up on date? 50?
Commencing 22nd July.
This is a matter for declaration of right title interest, confirmation of possession and permanent induction. I seek a short adjournment for this matter.
I oppose, Miller. In this case, appellant has taken adjournment more than 15 occasions, Miller.
Lordship, one last
And
chance will be granted.
in the previous bench, there is a peremptory order, Miller. In spite of that, adjournments are being taken.
Let us see.
Again. Order passed by honorable.
Begin. Let us see. We'll adjourn it. We'll make it, keep it part of it. The order sheet. What is the matter? Have you not?
Lordship, I'm seeking adjournment. I'm not well versed with the matter. Some time may be granted so that.
Why? How could you come to the court holding a brief and say that I'm not well versed?
Your Lordship, I was instructed.
Why am I not prepared? How do you know? You take it for granted that the court will grant time on your asking. I will not grant time. If you don't argue, I'll dismiss it. As simple as that.
And execution proceeding is stayed, Miller. Substantial question of law is framed, Lordship may see order number 23. Adverse possession is the issue. In one hand, they're disputing my title, and in other hand, they're claiming adverse possession.
What is your name?
Lordship, Varsha Mishra. Varsha Mishra.
Varsha. Ms. Varsha Mishra appears for the appellant and requests for an adjournment on the ground that she is not ready for hearing. As a last chance, the matter is adjourned to next week. Ms. Mishra shall address the court. You prepare? You will argue. I will not allow your senior to argue. All right?
Interim order to continue.
Interim order to continue to the next state. Yes.
Grateful.
Next
51.
This matter and for the appellate. In fact, I have prepared a note also. Question which the friend from Rayagada had entrusted the brief to me. In fact, he said that he would argue. I said that VC not possible. He has said to come. I am telling to my learned friend. But a time he has instructed me to make a request before the honorable court for
virtually सुनी है
maybe due to professional his side को कहीं मत कोइले मैं तो मना कर
all right, please this matter in the week commencing 22nd July as prayed for.
Item 52.
Interim order to continue.
Interim order to continue.
I'm for the respondent.
Who's for the none appears for the appellant on repeated calls. Is this matter in the week commencing? Yes, Mr. Das, you have another matter.
53.
This matter notice was issued last time, last year. कि appear करछन के ना
Notice ଯାଇଥିଲା?
आज्ञा point of law भी formulate ହେଇଛି. My lord has done. Consider point of law.
Order signing. Vivekananda Bhuya and Associates have entered appearance.
Appear करछन.
तो नाटा ले ही नहीं बोलते. नाटा बाहर नहीं. ना. The name of Sri Vivekananda Bhuya, Advocate and Associates, comma, who have entered appearance for the respondent be indicated in the cause title. Is this matter? Yeah, next week or next week.
And next to already I'm on accounts no putra bahagar already on account.
On 22nd, the week 22nd July.
29th.
Week on 29th, all right.
Item
55.
Item 55. None appears. Is this matter? August को नहीं जाता. Yes.
Your Lordship, done it 43.
Yes.
Your Lordship, I'll start placing the matter. to-
Yes. Yes. Very good. Very good. Item 43.
Yes, Your Lordship.
Very good. Who's your other side?
No one.
All right. Argue. Doesn't matter.
Your Lordship, this is the genealogy and the suit property for your kind perusal.
You are the plaintiff. Who are you?
And the, yes, Your Lordship, and the defendant number 5.
The confirming or reversing judgment?
It is a confirming judgment.
Confirming judgment. Yes. Suit was for?
Partition for the
Yes, place
filed
this.
by the plaintiff respondent claiming 1/3 share.
Place this.
Your Lordship. The common ancestor is Govinda Mahanta, who had 3 sons, Chandramohan, Shatrugna, and Harihar. Your Lordship, the legal heirs of Chandramohan are the defendants, and Shatrugna, the legal heirs of Shatrugna are the plaintiffs. The case of the plaintiff, Your Lordship, is that plaintiffs and defendant had no other joint land except the present suit land. In 1951, the 3 brothers, Chandramohan, Shatrughan, and Hari, they purchased land from one Lahangi via sale deed, and they jointly possessed and cultivated the lands, appropriating 1/3 of the share. In 1965,
Was there any deed of partition or orally?
the plaintiffs are asking for a partition.
No. Prior to that, how did they possess their respective shares, or how was the allotment of shares done? More orally?
Yes, Your Lordship. They were appropriating their shares.
Yes. Then?
Your Lordship, after the death of Chandramohan Mahanta, the plaintiffs were not allowed to cultivate the suit land. And hence the plaintiffs asked for partition in 1991. However, the defendant refused, and hence the suit has been filed by the plaintiffs. Your Lordship, the defendant in the courts below, D1 to D4 were set ex parte. Only D5 contested. Defendant 6 was later added by an order dated 8/4/96. So they both had different written statements.
Yes.
The defendant's case is that the suit property is not a joint property. There was an amicable partition in 1959 by meets and bound. The suit property fell into the share of Harihara and Chandramohan.
Fell in the share of Harihara and Chandramohan.
Chandramohan, yes, Your Lordship. The defendant 5 and the father of defendant 1 to 4. The suit and the defendant's claim is that the suit property is not the only property of the parties. There were ancestral properties in Keonjhar, Mayurbhanj, and Cuttack, which fell into the share of the plaintiffs. So during that partition, the share of the ancestral properties fell into the share of the plaintiffs, and the suit property fell into the share of defendants.
Yes.
And Lordship, D6 in the written statement claims that there has been an adverse possession against the owner, adverse possession due to ouster of the the plaintiffs. The learned trial court below framed issues on maintainability, pecuniary jurisdiction of the court, prior partition, cause of action, and plaintiff's entitlement to 1/3 share.
What was found under issue number 3?
Issue number 3, prior partition, Your Lordship.
What was the finding?
Your Lordship, may refer to page number 12, para 11. It was, it found that there was no prior partition.
All right.
The appellate court, Your Lordship, also found the confirmed the judgment of the trial court. Further, Your Lordship.
So what is wrong in it? What is wrong in this judgment?
Your Lordship, in the appellate stage, under Order 41, Rule 27, additional evidence was adduced regarding the sale deeds of the ancestral property, which indicate that there were prior.
That additional evidence was admitted.
No, Your Lordship, that was rejected, and that is one of the substantial questions.
Then
Your Lordship. Your Lordship may give me some time for examining these documents, the sale deeds.
What is your good name?
Manisha Mishra.
Monisha.
Okay.
Heard Miss Monisha Mishra, learned counsel appearing for the appellant. Heard in part. Heard in part. After arguing for some time, Miss Manisha Mishra, learned counsel for the petitioner, requests for an adjournment.
So,
in order to examine.
Appellant.
For the appellant, sorry. In order to examine further documents. Is this matter? Next week, come? Next week. Be prepared. Very good, very good. Prepare. Why is the finding wrong? That you have to justify it. Yes, somebody is mentioning.
My Lord, with your Lordship's kind permission.
Yes.
Item 13 of the weekly list was passed over.
Yes.
Therein, just a few minutes back, the copy of the leave application, because they are not parties, they have filed application for leave to file appeal.
Yes.
Explanation of delay application has been served on me.
Yes.
I pray your Lordship may fix it next Friday for hearing. I will file objection in the meanwhile, man.
Sir, कौन सी चार्ज नहीं थी?
नहीं थिला.
Sorry. All right. Let's this matter next week. Objection, if any, be filed in the meantime. It will come in the weekly list. All right.
My oblige.
Yes.
Also write on 5.
I'll 5 go.
Sir. Mate, please, my lord. My lord, item number 18 also was passed over, my lords.
Yes.
That lordship said admitted. It has come with an IA for stay. So, my lord, if your lordship may take it up next week. So,
Yes, it will come next week.
Lordship.
Item 8 next week.
Great.